Commission. You mentioned a matter. This is actually a PIL bills, which was heard by my Lord the Honorable Chief Justice, but due to some he recused from the matter due to some conflict of interest, and your Lord, my Lord the Honorable Chief Justice has assigned it to a bench headed by my Lord the Honorable Justice Sahoo. And this matter, there's a stay order operating against me, So if your Lordship would kindly consider taking up something.
Is it relates to that Cuttack PIL?
No. It is a PIL with relation to a land which also has link with the provisions of insolvency and bankruptcy code.
All right.
Yes, I have mentioned everything in the.
Okay.
Just praying for day after tomorrow, subject to.
We'll see if it is not day after tomorrow, then next week.
Grateful.
Two requisitions challenging the order on a tribunal.
Insolvency.
Two requisitions challenging the order on a tribunal. One relates to pension. By virtue of my lord's matter, I am not getting family pension, my lord. Second matter, the Lord Tribunal was pleased to reject my application for amendment, my lord. By virtue of pending of this requisition from my
Pardon to mention, my lord, the 2018 writ appeal is pending and the petitioner is suffering from equal pay for equal work.
Yes.
And it's a dead man.
All right.
Well, there's no item number 47 in your
Item number
27. 27.
Counsel is deleted. Item number 27. Was this matter before some of the bench in which one of us, Justice S.K. Sahoo, is not a party yet?
I beg pardon. My name of the advocate is incorrectly.
Yes.
Name of the advocate is incorrectly written. N.C. Sahoo.
After they mentioned it before that. Yes.
I beg pardon. Item 19.
19.
19. I am appearing the petition of the Union of India. In this case, I have filed the rejoinder yesterday. I have sought the copy on my lawn singer with appearing for the opposite party. I will kindly taken up on board and maybe listed on 30th.
Mr. Mahapatra and Counsel, you are the Central Government Counsel.
Senior panel counsel.
Senior panel counsel appearing for the Union of India submits that yesterday he has filed the rejoinder affidavit and copy has been served in the land counsel for the opposite party, which is not disputed by the land counsel for the opposite party. Stop. For the land counsel request the matter to be taken up next week. Is this matter in the week commencing from 30th of June 2020? Yes.
Back to partner, extension of time.
Extension of time for what?
Honorable Court is directed to deposit the pre-deposit fees of 30%, 35% of the amount in reality Kolkata. In the meantime, the petitioner is not deposited. Therefore, the petitioner filed an IA for extension of time to deposit the pre-deposit amount.
Who has passed that order?
My Lord Honorable Justice care of the
No, this court has passed that order to deposit 30%.
35%.
35%.
In the meantime, it is not deposited. Therefore, it is.
But the order has been passed by the division bench, another division bench. So extension, if any, is to be take instruction whether it has to be listed.
It is in the form of modification or in the only extension.
What are the
Supplementary list, item number 1.
In item 1, there are 2 items.
Yes.
First item, and friend is appearing for the petition. In the second item, Lordship has been pleased to issue notice on 6/1/2025. But the opposite party has entered appearance and has not filed any counter appearance. Lordship kindly have a glance to
Who is appearing for the opposite parties? In second item.
So where gets
These are interconnected.
It's connected in both the.
Mr. Das, you are appearing for the opposite party in the second item.
second item and as well as in the first item also. ma'am.
It's all right.
Yes.
Do you not intend to file any counter affidavit in that second item?
Your lordship would see it will not counter affidavit.
No, it
will
is
not
up
be
to you.
required.
If you don't find, then the government remains undisputed.
Your lordship,
You
just,
say it is infractuous.
your lordship, just I beg your lordship to hear me for 1 minute. Thereafter, I will take your lordship's whatever your lordship should desire. I will comply.
No,
Before
it's not
going
our,
to the-
No,
it's not
it
our
is up
desire,
to you.
it's your
It is
desire.
up to
But
you.
you
It's a question relating to my lord. Rehabilitation assistance by appointment because of land acquisition by the railways for a project. The
The
notification was there.
prayer has been made for, what prayer has been made? To was the order dated 24/2015
Yes.
passed by the London Central Administrative Tribunal,
Yes.
Cuttack Bench. And
That
the,
is no longer available to them.
just a minute, in the operative part, in paragraph number 9, it has been held that the respondents are hereby directed to consider the case of the applicant in the light of the notification dated so and so of this court in Krishna Chandra Nayak and communicate the result of such consideration to the applicant within the outer limit of 90 days.
Must.
Right? So,
So here
Just,
I will just add to your lordship's observation, what is Krishna Chandra Naik? Krishna Chandra Naik is a similar and identically placed person. Your lordship directed him to be appointed. Railway did not give and went up to the Honorable Supreme Court.
who is this man? Milan Kumar Devusarkar, who has filed the writ petition. He is not a party to that proceeding?
No, he is in the second,
He is seeking benefit of Krishna Chandra.
No. So
no,
far the second,
he is the contender.
so far second item is that writ application was disposed of. Subsequently, OA was disposed of. We have carried out the order passed by the OML. The lordship has observed in order dated 6/1/2025 in detail. The order has already been carried out. We have rejected the prayer of the opposite party. Instead of filing any original application, he has filed contempt application. In contempt application, notice was issued for personal appearance. That is why I have challenged the officers, Mr. Midin Kumar Devasekar and others are the officers of the.
That means what you are saying is in so far as
Yes.
Second
this order is concerned, you have complied.
Second bit, my lord, the genesis says.
What he says is within 90 days they were supposed to dispose of your representation or consideration. They have done it and
But there is a
rejected.
gap, my lord.
Rejected.
That 90 days consideration is passed in the first case. What your lordship, my lord Justice Sahoo was putting.
But you have not challenged that order.
No, that order they challenged before this honorable court, stating that in one of the cases, this honorable court set aside the order of the tribunal, so that order may be carried out in that case. But the same order, this honorable court reviewed, and the writ petition which was supposed to be guiding the result of this present writ petition was dismissed.
It needs hearing. It needs hearing.
Brings it all those matters by filing a small counter.
Yes, I will tell it.
That would be-
And in the second case, what my friend Sri Bhokta suggests, the contender, what he does, first, the tribunal passes an order, they did not comply, and after direction, they passed an order saying that this is the compliance. And the compliance is what? The exact photocopy of the previous order which the relevant tribunal passed. Thereafter, the tribunal said,
Non-compliance is no contempt.
here, the order which
Yes,
was,
compliance, wrong or right. You have to press cause of action, challenge that.
my lord, that is how many times would I challenge? Thrice, I have challenged once, again twice. The tribunal directed them to consider, and the order which was passed was passed again. And they
But,
say,
the
you challenge it
contempt-
again.
But the contempt petition is still sub judice before the grand trial.
This, before the relevant tribunal.
Right, so
Yes.
let it be disposed of. Let it see, if you convince
Yes.
the tribunal that what they have complied is not what the order was passed, the tribunal may not accept the order and may pass some order, but we will not say anything. So you just,
That is my only prayer before Lordship. Your Lordship has been stayed.
Lordship kindly
You
have
have
a
been
glance
pleased to
to
stay that order.
Mr. S.S. Das, Land Counsel, appearing for the opposite party in both the writ petition, seek some time to file the counter affidavit. Put up this matter on such and such date, counter affidavit to can be filed in the meantime, serving copy on the Land Counsel for the respective petition. Put up date date. Next.
Item 2.
Both the writ petitions are to be taken.
Yes. And this
an interim order in second.
interim order is
Interim order means
Not to proceed with the contempt application.
interim order dated. Which order?
order dated 6/1/2025 in WPC number 2948.
Without insisting for personal appearance. Decision for the.
The order dated one, so what was
stated-
that order? 31/1/2024.
6/1/2025, that is the order for personal appearance.
So personal appearance,
We will
we
dispense
say
with.
that we are dispensing with.
Let the contempt petition be decided.
We have just state, order dated means that is so far as relates to personal appearance. It doesn't mean that contempt petition we have,
Your Lordship may indicate.
Yes, let the contempt petition be decided.
that is order was passed in WPC number 29485. Voilà. Likhi diyo uनको. It appears that in IN number secondary appeal 15582 of 2024, I had order dated 6/1/2025. We have passed an order. No, this court has passed an order for staying the order dated 31/1/2024.
The 31/1/2024 order, that is at page 23 and 24, in with the facts and that matter. Again, a direction was issued to consider to dispose of.
It is not for personal appearance.
No, for personal appearance.
So,
Not for, again,
okay,
when
chalo.
we.
Personal appearance पे
नहीं,
mistake.
personal appearance इतने है ही नहीं. What happened? In spite, the Lordship kindly have a glance
ठीक
to.
है जी. Personal appearance is
नहीं.
it is to be extended upon. The order dated
The contempt application disposed of.
interim.
Already disposed.
Dispose of.
Interim
Direct,
order
again
dated
to consider, my.
interim order dated 6/1/2025 passed in WPC numbers. Once you see it, shall continue till the next date.
After it application, my appearance for the petition has been open.
अच्छा first लिख दिया WPC number 13748 Mr. Siddharth Shankar Mahapatra, learned senior panel counsel na, is present.
Both the writ application will.
It will be taken. Yes.
The Lordship fixes the date.
You'll come 2 weeks after. In the meantime, you are supposed to file the counter affidavit serving copy on the land council for the. Yes, next.
Okay.
Item 2.
Madam, on behalf of Mr. Nihal, I seek for a short adjournment. Matter may be posted any day after 7 July.
Where is Miss Mahapatra?
Patra has requested that he has some personal difficulty, may be taken up some other time.
Any interim order has been passed?
No interim right.
All right. What is your good name, Land Council?
Shreyansh Rajguru.
Give it name. You are mentioning on behalf of Mr. Nihal Ratha.
Yes, madam.
All right, so and so, appearing on behalf of Mr. Nihal Ratha, seeks for an adjournment. Miss, Mr. So and so, Mr. Dipti Ranjan Gupta appearing for Dipali Mahapatra, Land Council for the opposite party, submits that he has received instructions that Ms. Mahapatra has no objection for adjournment. This matter on such and such date with WPC number 30354/2024. Yeah,
The matter may be posted 2 weeks after.
yeah, 2 weeks after posting. It likely there were 2 weeks after posting, 2 weeks after date. Yes,
Item 3.
My lord, item 3, 2 months time may kindly be given as my senior has gone abroad for his medical treatment.
you are appearing for whom?
I am appearing for the
Petitioner.
petition.
Mr. Karunakar Jena, you are seeking adjournment. What is your good name?
My name is Siddharth Kumar Das.
Let's write it down. You are appearing, Mr. Pati, for the,
Opposite party number 1
all right.
in and apprentice.
Mr. Manoj Kumar Patil and senior panel counsel is present. Mr. So appearing on behalf of Mr. Karunakar Jena submits that Mr. Jena has been to abroad for his health checkup, and the matter may be adjourned. For what days?
My lord, after 15th August, any day.
After 15th August. Any interim order has been passed?
No, my lord.
15th August. Please, this matter be with accurate.
Item 4.
May.
Yes.
My lord, in compliance to minus order set 24th April 2025, I have filed a copy of Procedural way. Objection filed by the present opposite parties to my application for amendment. Order passed by the non-tribunal allowing my application for amendment, and order by which time was granted to the opposite parties to file additional counter to my amended way, my lord.
Yes.
Along with the memo, I have already filed.
And you have given the copies to
I
me.
Yes, I have received.
Uh,
I have received with me. I have received with me. I have solved a copy and I have received with me.
no, he is admits.
I need a day's time to get the copy also. Copy has not been given to us yet.
He has got the receipt what you are doing.
Procedural, probably the clerk have not given it to us.
You have not got, but the
Doctor must have got.
Just
No, give it
verify,
this
just
time.
verify about the,
Very.
the London Counsel for the petitioner, Mr. Rautray, submits that as per the order dated 24/4/2025, all the documents have been filed and the copies have been served on the Land Council for the opposite party. Mr. Asutosh Mahanti, Land Central Government Council, submits that the documents have not been tagged to be filed and the matter may be taken up some other day to verify regarding receipt of those documents. List this matter. Next week, was it?
Anytime, anytime.
Yes.
Item 5.
Is for the petitioner. Virendra Kumar Mahapatra. What is this matter, Mr. Niyamati?
Challenging the surface act, this alternative remedy is available under 67.
What is the stage now?
Lords,
What he has challenged exactly?
actually copy has not been served, but earlier he has challenged the auction notice, that auction notice failed because of the non-participation of the bidder mother. So now most probably he has challenged.
He has challenged the 11/2/2025 notice. 13/4, then again another prayer is to same notice, that is 13/4, and contemplated direction may be issued to OP directing to reconsider the order passed in so and so by this to settle the, there was an order passed earlier,
For this, to approach.
one-time
the-
settlement scheme.
But
What
he-
happened?
But he approached my lord, so in this case, the dues is more than 20 lakhs. He has offered only 3 lakhs. Naturally, it failed.
No, have you communicated the order that, no, we are not agreeable to?
All verbal notes. He has not given any.
No, he has submitted the postal receipt, the copy of the, the copy has not been
He has not.
served on it. Sure. Because Annexure 5 series is the
Communication.
proposal which has been given by him in terms of the order passed by this court.
If the copy will be served on me, I will take it.
The council is not there.
Password.
So,
Let us password, let us see.
No, sir.
You have
This
problem.
is a personal.
Acha, we are keeping it to next week,
Well,
like non-appears for the petitioner. Mr. KMH Niyamathi, Land Council appearing for the bank submits that he has not been served copy of the writ petition. Stop. Place this matter on 1st of July 2025. Copy of the writ petition is served in the meantime on the Land Council for the opposite party bank. है ना? हाँ, 1/7/2025. Yes.
okay.
Item 6.
Yeah, may I please mind. You are challenging the order dated 2nd April 2025, passed in roll number 449 of 2018 under Annex of 13, page 56. The petitioner is before my. You will also kindly evidence page 64, the operative part of the order passed by the Honorable Tribunal rejecting my original application. In the instant case, obviously and axiomatically from the
Just a minute. This matter was taken up on 2/5/25.
my. On that day, my lord was pleased to allow my IA and permitted to me replace the first and second page of the petition.
No, we have not allowed your IA. We have you got that order on 2/5/25? Please see the order dated 2/5/25. Oh, where is that? That is the only order passed in this petition. Please read it out now.
One counsel for the petition submits that it intends to file an internal application for amendment of the prospectus to also para number 1 of the petition and sometime may be granted in that respect. I have already filed that.
So that has been listed for consideration, but you said that interim application has been allowed, so. So, Mr. Patnaik, you are appearing for the opposite parties.
Opposite party.
You have received the copy of the writ petition and the interim application which has been
My lord,
filed.
I have received IA number 7763 of 25.
Yes, that is the.
My lord.
So that has come for order. What is the prayer in that IA?
My lord, the prayer is the petitioner humbly prays that the honorable court may graciously be pleased to allow this interim application and permit to the proposed amendment. Just for an amendment.
Yes, so this is formal amendment. So in paragraph 1, 2 of the writ petition, this has to be made, and what further? Have you got a consolidated writ petition with you now? Because that paragraph is to be changed now. Are you having that copy? So file it also. We are allowing this. You're filing. What is that?
7/5 along with a memo.
Just a minute. We'll allow, but if you have, no, this is not on record. when you have filed the consolidated writ petition? 7.5, incorporating this paragraph 1.
Replacing page 1 and 2 of the decision. Memo is
Memo, which is here, the memo which you have filed on 9/5/25, that carries the original application and the reply to the reasoned affidavit.
May I pray my Lord should grant me one day time so that I can file today.
That page is just to be changed.
Okay.
IA number 7763 of 2025. There is an application for amendment. Land Counsel for the Union of India, Mr. Patnaik. Land Senior Panel Counsel submits that he has received the copy of the interim application and he has no objections to the amendment sought for. So, after hearing the Land Counsel for both the parties and going through the interim application, the prayer made in the interim application is allowed. The Land Counsel for the petitioner takes 1 day time to file the page number. Who page to file करेंगे?
1, 2.
Page number 1 तक ही file करेंगे कौन ही चीज़ है?
कोई नंबर का डेट तक
Oh, अच्छा. Page number 1 and 2 on the writ petition, serving copy on the Land Counsel for the opposite party, है ना? So you file by tomorrow so that it can come on Monday. List this matter on 30th of June 2025.
Item 7.
IA is disposed of, है ना? Okay. This matter. You are challenging 2/3/2024 order.
Yes, sir. Limitedly,
That is annexure 1.
yes, sir. In limited way, in the sense that the ombudsman has held that the distribution licensee in imposing reliable surcharge at the rate of 10%.
Refund reliable success.
Reliable surcharge has not followed the procedure of OARC tariff order, and that is quoted. In blatant violation of the regulatory framework, they have imposed it. Now, allow me for the 2 period, deny me for the balance, saying that it's barred by limitation. That's under challenge. My case is that in the Electricity Act, for approaching VRF, and there is no limitation has not been there is
Prescribed.
yes, madam, prescribed. And the OERC code doesn't say so. That's number 1. Number 2, my lord, for the period 15-16, they have revised the bill in the year 2017. For some other reason, saying that distribution and losses has not been accounted for in respect of the imported unit of electricity. So that's how the litigation started. I came up before this honorable court. This honorable court relegated me to GRF, and GRF I lost, and I approached ombudsman. In that proceeding, I raised this. So it is post that their revised bill. And that while the matter.
But the ombudsman has taken the general principle
Yes.
of 3 years recovery
Yes.
period. 3 years recovery. You can't sleep.
No, I am saying that, my lord, illegal exaction of which I have no knowledge. How can it runs against? Man, they are required to obey the law, and they are not obeying law, and they are defrauding me. It's only when I came to know I filed it. That's your lordship.
Where is the knowledge? Where have you said the knowledge? From the knowledge, 3 years.
Up to, well, so that's the law. Paragraph 5 has stated this. They have been, now their own tribunal, ombudsman has found it that they have cheated. Lastly, my lord, the Electricity Act doesn't provide for any limitations for the consumer to approach. Second is this, even the general law explanation. And third is that there is a continuous litigation since 2017.
No, it appears that it is electricity bills for the period 2015 and 16.
Yes, madam.
So when it was raised?
No, it was raised in 2015 and 16.
No.
And this subsequently it was revised in again, that 15-16 was revised in 2017.
2017.
17.
Okay, then what happened?
Then I came before this honorable court challenge on some other grounds. Then I came before this honorable court.
Yes, what happened?
I was relegated back to the GRF. GRF, I lost. I approached the ombudsman. I raised this point, and your lordship find out at page 69, the ombudsman says that you have to re-raise the issue of reliability surcharge before the.
Where is that?
Page 69.
69.
Yes. This is the first challenge culminated in the ombudsman. Regarding the reliability surcharge, the petitioner has not raised before the GRF. So the authorities of the opinion to direct the petitioner to approach learning GRF in this regard.
What happened then?
Then I approached the GRF, and the GRF I lost, and I came back to the ombudsman. Ombudsman allowed 2 period, denied this. So my case is that this is a continuous.
What is the amount involved?
Amount involved in
Which is
staggering matter.
What is denied to you?
Well, allow is of course 48 and 37 lakhs. The denied is more than 60 lakhs. Or around 50.
Do you have any judgment that Limitation Act doesn't apply to electricity?
I do have a judgment, but it says that that Justice Chandrachud has been
But
the Chief
no,
Justice of
Limitation Act in the sense that it is, you are raising the dispute at right time, then it goes back from one forum to another forum. Ultimately,
yes.
the order has been passed on 2/3/2020.
Yes.
So what was denied to you in which paragraph?
This denied is, my lord, impugned order.
Paragraph 6 and 7.
Yeah, lordship, page 42,
42, 6 and 7.
paragraph 6 and 7.
Please place that paragraph, Ganesh.
The claimant petitioner is purely the claim of the petitioner is purely a money claim for refund of the money which should have been made within 3 years. The claim for refund was made on 7/7/2023. So the claim of refund of money already paid reliability surcharge on before the thing is banned. My submission is here, my lord. I am not claiming for refund. I have said the imposition is bad.
Oh, you are twisting the words.
Same thing.
No, my lord.
The refund only.
No, my lord. If they justify.
Do you have any judgment to suggest that in the Electricity Act, the Limitation Act doesn't apply?
No, that's one.
Then the general principle is
If your lordship hold
3 years limitation.
Yeah, lordship hold the general principle also. I say my knowledge. A and B. This is a continuation proceeding. These
No,
are the
knowledge you cannot deny because you are
defrauded, my lord. It's a fraud being committed on me. It's a fraud. The ombudsman himself has held that nothing has been adhered to in seeking. Now we all pay electricity bill, my lord. We are not very much sure of what is their asking for.
It's inflation of this thoughts. The question of.
no. If you are taking please come to the paragraph number 7
Yes.
of the impugned order,
Yes.
where it is stated that limitation
Money
period
claim.
has been fixed in Limitation Act for money claim.
Money claim.
If someone, yes, please.
Someone has either paid in excess or claimed less, then within the limitation period, the person has a right to claim for a refund or make an additional claim for such. Yes, that's it.
Then read the next.
Hence, this authority is of the opinion that the amount paid by the petitioner towards reliability surcharge on or before 8/7/2020 should be on or after 2020 should be refunded by the respondent to the
You are seeking refund of surcharge amount which you have paid. So therefore, he says that the money claim,
Nah.
3 years limitation.
No, I'm saying that
After that, he is not entitled to
it is
that.
not
That's what-
impossible. It's not impossible. My lord, first and I'll say that it is not impossible. And because they have imposed it in violation of the tariff order. And that he has found correct. Well, two things. One, sir,
We understood.
what there is a declaration and subsequent consequential action.
Where is the declaration in this order?
Yes, my lord, your lordship, that it is imposed on.
Not imposable.
Yes, ma'am. Then all period he has held not.
So was. Reliability surcharge is not imposable. Where is the finding?
Your lordship, no?
Come to the
Page
finding and
41.
analysis. Page 40, the finding and analysis.
In page 41, your lordship, in the tariff order of financial year 2015 and 16.
No, you come to page number 40, finding and analysis, paragraph number 2.
Yes, sir. The petition of claim of refund of reliability surcharge is based on the allegation that the respondent had not provided the reliability index calculation and the voltage variation report along with the bill in whichever month the reliability surcharge is being levied.
Okay. Then that was refuted. What is the finding on this?
The finding is that they have not given.
Where is that?
Technically speaking, there is no denial to the fact that said in the tariff order, the reliability surcharge was levied on ST and EST consumers.
Just show us that finding. We are not going to, the reasoning we are not.
No, fine. My lord, last time taking 42. As per the above regulation, the respondent must have record of the dispatch of a bill along with the report, and the report is an integral part of the bill. And in case of levy of reliability surcharge, the respondent did not furnish any such record on the other hand. It is not sensible to expect that petitioners provide the material evidence to prove that he has not received the document. Hence, it is concluded that reliability surcharge. Before that, they say that the tariff order says.
This is not the finding.
Technically speaking, my lord, part 4B.
But you say it is not chargeable at all.
Yes, my lord.
Where is that finding?
4B.
Then the limitation may not
That's for
be read against you.
Show us that. Would be.
Reliability surcharge was, I am placing finding 40, page 41(4), paragraph 4. Reliability surcharge was first levied in the tariff order for the year 2013-14 on EST and HT consumers availing the power supply through dedicated feeder. The purpose of levying such surcharge has to be clearly explained in the tariff order. For claiming reliability surcharge, two conditions has to be satisfied. Reliability index at the consumer's end had to be maintained the above specified level and the voltage variations as for OESC standard performance regulation 2004. Discoms were directed to attach the report with the bill in case levy of the reliability surcharge. The consumer were not required to pay any charge for this report to be attached with the bill. In the tariff order financial year 15 and 16, reliability surcharge was levied on HT and Mishra availing supply through share feeder in addition to the category of the consumer on whose the surcharge was being levied since 2013 and 14. In this order, it has been mentioned that it is further directed that Discom shall attach the reliability index calculation and the voltage variation report with the bill in case levy of reliability surcharge. No reliability surcharge is payable unless this report is attached to the bill. Now, this finding has never attached. Last finding. Technically speaking, there is no denying of the fact that share feeder, the probability of reliability index being lower and the voltage variation being higher is more when compared to the dedicated feeder. This is the reason some consumer invest a lot of money for constructing dedicated feeder if they wish reliable power without much voltage variation. Hence, Honorable Regulatory Commission directed that the report must be attached to the bill in case reliability surcharge is levied on the consumer. At the same time, it was emphasized that
In the absence of that report, it is not chargeable.
Chargeable.
That is the finding.
That's the-
But in your case, whether
Yes,
the
that
report was
it is
attached,
what has happened.
They have not given.
where is that?
That's page 42, paragraph 5, bottom.
42.
As per the above regulation.
that is where you place that paragraph 5.
Paragraph 5. The respondent asserts that the petitioner had paid the reliable surcharge without raising objection at the time. It is to be presumed that the report was furnished with the bill. The respondent also submits that the onus of proving.
That's the case. You have deposited. Whether a report is there or not, nobody knows. Now you are seeking refund. Therefore, they say that it is a refund, okay, claim of refund.
No, they have a failure to produce it. The lordship can, I am just putting it.
Conclusion has been given in your favor.
Yes, madam. That it should have been with them. I have not received. They have never have this report. Therefore, they are unable to produce. Madam, just imagine this is a discount. They are charging 10 rupees per unity. They are unable to produce anything before their own ombudsman.
You are Bajrang Wali, you can do anything.
Madam, these amounts, it do slip, sir. Many things have been written in that electricity bill. Nobody actually goes.
Who is appearing for
No, it notices to go.
Sure. The petition has been filed by the petitioner for Counsel challenging such and such. Mr. Rothon, Land Counsel, appearing for the petitioner, drew the attention of this court to the improvement order under Annexure 1 and the findings and analysis wherein the learning ombudsman has been pleased to hold that the respondent, that is Executive Engineer Electrical RED, TPW, ODL, Rajgangpur, had not furnished the report. What is that report called?
Reliability index.
The report is for.
The reliability index calculation and voltage variation.
Yes, reliability index and voltage variation report.
Reliability
42 second line. 42. Reliability index and voltage variation calculation report.
Reliability index and
voltage variation calculation
report. No, along with the bills, whenever a reliability surcharge was levied, and however, taking into account the provision of the Limitation Act, which states that in case of a money claim, the prayer can be made for refund within 3 years. The Land Ombudsman has held that the amount paid by the petitioner towards reliability surcharge on or after 8/7/2020 should be refunded by the respondent to the petitioner.
But before 2020, it is not recovering.
The Land and Council submission is that the non-grant of the relief, a similar relief for the period prior to 8/7/2020 is not proper and justified in as much as not only the petitioner was pursuing the matter from forum to forum right from 2017, but in view of the provisions of regulation 147 bracketary 1 regulation 147 bracketary 1 of Odisha Electricity Regulatory Commission Distribution bracketary conditions of supply for 2019. Since necessary document has not been furnished,
A report, necessary report.
that is the report with the bill. The denial is quite unjustified. Stop. Moreover, in the factual scenario, the Land Ombudsman was not proper in applying the provisions of the Limitation Act. Stop. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. So no notice is required to be issued to opposite
No.
party number one.
Yeah, not
Only
necessary.
notice is required to be issued to the opposite party number one.
Just
The requisites for issuance of notice, I speak to with proof of delivery. The opposite party number 2 shall be filed by next week is this matter. 4 weeks after counter affidavit, if any, be filed in the meantime. Yes.
Major, coincidentally, the other issues is pending in item number 22 before a lordship in the same. And in that matter, when Mr. Party is appearing, the lordship there is 22 is appearing the same out of the same issue. First issue which is adjudicated in my.
No, if he is the only counsel, you would have said that it may be that they might have the panel of counsel, so they may engage somebody else. They engage, there is no problem. So, yes, next.
22 also same.
No. 22 is something they have come.
Yes, next.
Item 8.
Please, your Lord. My Lord, the petitioner has challenged the order under Annex 7 dated 3/12/2024 passed by the Central Administrative Tribunal in OA number, my Lord, 212 of 2019, thereby allowing the original application against the petitioner. The fact of the case is that the present petitioner was working as a pointsman in railway. During the course of his employment on 26/7/2016, he being a drunken condition entered into the chamber of the DO and divisional operations.
Drunken condition.
Drunken condition.
This lady.
No, my Lord, husband of the present petitioner.
Okay.
She died.
She died. He died.
He died and
Thereafter,
Appointment.
my Lord, I'm placing my Lord.
was
Hmm.
Entered into the office of the DOM AGB
Hmm.
and abused him in filthy language and thereafter told rival-dry attitude and thereafter a disciplinary proceeding was initiated. He was put under suspension and in the proceeding he was noticed and after being noticed she filed her so-called admitting everything. She was always remaining in a drunken state and he was also deviating from his official duty. After taking into consideration all the aspects, my Lord, he was dismissed from service by imposing a major penalty. Thereafter, against the order, he preferred appeal. And
He was alive by then.
he was alive by then.
Yes, then what happened?
Then he preferred appeal.
charges were quashed.
My Lord, the appeal was also confirmed. The order of appeal was also communicated to him.
Yes, then.
So thereafter, he died. Immediately after communication of the order, he died.
Hmm.
The wife of the present petitioner, the wife of the my lord delinquent,
Yeah.
he filed way before the Central Administrative Tribunal, indicate praying for a prayer for to allow him to file a revision against the order. It was directed by the Central Tribunal, and on the basis of the order of the Central Tribunal, she filed a representation which was treated as a revision, and ultimately revision was also confirmed the order of the both the courts below. Thereafter, challenging the said order, she preferred a way before the Central Tribunal.
Which is the impugned order.
This is the impugned order.
Yeah, what finding is given?
Your Lordship may kindly see.
Come to
Well,
page 106.
When the Learned Tribunal.
Now come to page 106, operating part.
Yes, madam.
What is wrong with it?
The Learned Tribunal, madam, 106 is the last paragraph.
Para 10.
Order
10 and
11 as the ordering portion.
Read it.
In this way, the prayer of the applicant is to give her appointment on compassionate ground, and after passing the charge sheet dated 7/10/2016, inquiry report dated 28/11/2016, and punishment notice dated 19/1/2017. In view of the discussions and directions made in paragraph 9 above, the respondents are also directed to consider the case of the applicant for appointment on compassionate ground in accordance with rules and law within the period as directed.
So what
Only
is
for
it?
consideration.
Sir, I have challenged.
Consider it.
My lord,
You say there is no compulsion that you are to give it.
my lord.
Huh?
My lord, my humble submission is, my lord, the order passed by the disciplinary authority, appellate authority, as well as the revisional authority is crossed by this order.
You have to consider it on compassionate ground in accordance with your rules and law. If you say that your rules and law does not permit for such compassionate appointment, communicate the order to him. Why are you challenging here?
But my humble submission is, if the order of the disciplinary authority goes, then, my lord, she will be entitled to all the benefits, my lord.
No, that order has not been passed. It is just only for appointment on compassionate ground. He has not stated, the tribunal has not stated that any kind of other reliefs is to be granted to the lady. Only said that consider the case of the wife of that delinquent on compassionate ground. That's all. No other relief has been granted. And if such compassionate appointment is permissible under your rule and law, give it, otherwise deny it. So you are just to consider and deny or communicate the order. No other relief has been granted. So your submission, but that she may claim. So that is not the order.
But in the ordering
in that circumstances, she would have come to this court. I am not only prayed for this compassionate appointment, I have also prayed for my husband's this salary, etc., etc. That is not the lady has not come before us. You are coming to us. So
yes, sir.
This is a limited relief has
But in the
granted.
findings,
For Union of India, small employee, for small post, some peon, some post. Why are you?
Consider, my lord, my humble submission is, the Learned Tribunal, without going into the merits of the case,
You should curtail litigation. You are a Union of India. It's a consideration of
employee
some peon and all.
Se kebetu employment thila.
the employment.
You see, we do not know since when he was in service. This occurrence took place on one particular date.
But the offense took place in the year 2016.
27/7/2016 दिन मद पीकी जाई गाड़ी कला. That's all. The allegation is that. So you have And thereafter you have inquired, imposed the major penalty. He was out of job. Then he died. Ultimately, his wife is telling that so this much. If you say that your rule does not permit, you say communicate the order. But the allegation is not that this lady was doing all those things. His husband had done it on one occasion.
It was on several occasions. Yeah, you were-
No. It's not that. That is
For
not the
one
charge.
occasion, the proceeding was initiated.
That is, you cannot say now that on several occasions he was doing. The charge is very
27/7/2016.
specific charge.
That is-
Specific charge on 26/7 or 27/7/2016. He entered into the chamber, abused the senior. That's all.
There is also in the inquiry report, it is indicated that she was regularly remaining in a drunken state. If your lordship.
If such finding has been given, that is very perverse in nature. If your charge is not that, how can the inquiry officer give such a finding?
But this proceeding is with regard to that particular
So particular
incident.
date is there given.
That
How can the
particular
inquiry
incident.
officer give a finding? You must frame specific charges against him so that he can reply and then face the proceeding.
Well, my humble submission is the Law and Central Tribunal has also set aside the
No.
order of my lord,
All right.
disciplinary
The
authority
petition
as
has
well
been
as
filed by the Union of India challenging the order dated 9/12/2024 passed by the Line and Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 260/00212 of 2019 with OA number so and so. It appears that the opposite party Swarnalata Panigrahi filed both the writ petitions. The two writ petitions, the opposite two writ petitions. And in OA number, may I interrupt? 260/00212 of 2019, she has prayed for a direction to the petitioners to release the withheld arrear salary of her husband, late Gauranga Kumar Panigrahi, who was working as points man bracketry A BNBR under SMR/BNBR and family pension and other pensionary dues in her favor by quashing the charge sheet dated 7/1/2016, the report of the inquiring officer dated 28/11/2016, punishment notice dated 19/1/2017, and order number 12/2019. Stop. In OA number 260/00046 of 2020, the opposite party, what is the prayer in that petition?
Well, my lord, but Annexure 6 is the writ petition. There was to pass
Annexure 6, acha. Annexure 6.
Yes, sir.
No, we are on this second one, second one means,
13029.
46 by 2020. 46 by 2020 of the each and the original application done. What was the prayer? He is the applicant in both the way. First one we have already dictated, and so far as the second one is concerned, 260/46/2020. So what was the prayer in there? This original application which you have annexed, that is 2019. In 2020, what was his prayer? Is it mentioned in the order?
Not there in the,
Hmm. It is mentioned that it has been
Yes,
interlinked.
my lord, but it is not there in the list, my lord.
Contrary.
Other writ application. Data nine.
No, this is a common order pass.
Common order pass, but
So
two
common
separate
order pass, we just
applications
want to
are
know that whether you have got the original application of that 46 by 2020.
filed. Against that order,
Yes.
another writ application is filed.
Okay.
Because
But this is confined
this is confined to
This-
212 of 2019.
19. All right.
19, my lord.
All right. Let on.
May I
The-
submit, my lord?
Yes.
Your lordship, kindly see paragraph 9. Paragraph 9 of the judgment, final order,
Yeah.
at page 105. The finding is that in view of the facts and law discussed above, the net result is that the impugned order dated 1/3/2017 and the order dated 12/2/2019, such and such, are not sustainable in the eye of law. Although number of collateral issues had been raised by the Learned Counsel for appellant, we deem it appropriate not to opine on the same in view of the conclusion reached above. Since government servant, husband of the appellant is no more, based on the punishment notice of such and such, his family members cannot be deprived of the death cum retirement benefits. And in such circumstances, remanding the matter would not meet the ends of justice. Hence, the respondents are hereby directed to release all the benefits to the applicants. As if her husband
So
expired.
just a minute. So 2019
Yes.
order a portion of file
Eight hours.
out 2025 you have filed another writ.
Another writ application.
What is that writ petition number?
I don't have the number, my lord. Some other lawyer is alleging that.
Then both the matters should have
This
heard
should be-
together.
that is.
Let both the matters come together.
But you have to give the number. You must have challenged that.
No, my lord, I have not filed it.
But union
I have to
affiliation.
verify from the office, my lord.
Acha. On liquid.
It has not been entrusted.
So on. So the type of liquid of the common order has been passed. No? ये करो in 2019 the order ta likha hai jeti, you see I am giving you the page number. That is 2019 a order passage that the respondents are directed or the petitioners were directed to release all the benefits to the applicant. Death cum retirement benefits for them to the opposite party for them. As if her husband while in service as if her husband expired while in service. So far as way number 260 of /46 of 2020 is concerned, the Learned Tribunal has passed the order that the petitioners directed the petitioners to consider the case of the opposite party for appointment on compassionate ground in accordance with rules and law. The Learned Counsel for the Union of India submits that this writ petition as challenged in this writ petition, challenge has been made to the order dated 9/12/2024, passed in so and so.
212/9.
Likhi devadi. But he may be given some time whether any challenge has been made to the same order relating to the allowing the prayer of the opposite party passed in
OA number
OA number 260/00212 of
0046.
Huh?
0046.
0046 of 2020.
21.
Whether challenge or not. So let it be listed on. It should have said so is 7th of July 2025.
The original main application, this is the main original application. So I thought I will move
It's
it.
all right. Dita application को common order कर देइछन्ति.
Again, that created confusion.
Relief टा अलगा अलगा मध्य देइछन्ति. एई जो relief टा पाई आपनकर एटा पास हेछि 2019 रो ओरिजिनल एप्लीकेशन.
Again.
2020 रे जो relief टा हेछि सेटा पाई आपण आउ गोटे रिट ओरिजिनल जो रिट पिटिशन फाइल करछन कि नाही. You obtain that instruction will take up on 7th of July 2025.
Right.
देखिए देते हैं.
Item 9.
Wait, the seat application is fine. Against the order basking way number 283 of 2023 under annexure 7. They have already appeared and filed their counter today. I have not gone through it, but my
Counter, but notice has not been issued. They have just entered.
I have entered through caveat, that is why I preferred a count.
Acha, all right.
Otherwise.
Lord, just we'll maintain the formalities then.
Fine.
Lekondu. This writ petition has been filed by the petitioners challenging the order dated 16/4/2025 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 283 of 2023. Under annexure 7. In the original application, Mr. Mahanti, you are the respondent number 2, na?
one and two.
OA.
In the
One
OA.
and two.
Respondent number 2. Top. And
Respondent number 2 to be
right.
more specific.
2 and 3, direct road.
Mr. Das, you are for
I'm
the
the applicant. The
applicant.
OA.
applicant, yes.
There are two
two
applicants.
applicants.
Two applicants.
I am appearing.
All right. The original application was filed by the applicants Manas Ranjan Nayak and Hare Krishna Sethi, who are the opposite parties number 1 and 2 in this writ petition. And what order you are challenged in that 14/1/2023? What is that order? Which you challenged before the London Tribunal?
Tribunal, my lord, a notice was issued by the STPI, that software technology, my London.
No, you come to the, you have received a
Yeah.
copy of the writ petition.
Yes, sir.
You come to the page number 93, a running page, but it is internal page 18, paragraph number 8.
I'm sorry, madam, I could not follow. Paste,
Page hଉଛି internal page is 18
my lord.
of and paragraph number 8
Tribunal order.
tribunal order ଟା ଯୋଉଟା କି annex ହେଇଛି annexure 7
In the instant case, so that it begins with the address,
93, page 93.
Yes,
application the copy, the writ application.
yes, I have the I've got the writ application copy Xerox for my lord. Can I give it so that it will be?
No, read the impugn order. Internal page
You
18.
just want to know,
Instant case, admittedly, the
Ah.
applicant
please explain.
applicant two has working under the respondents in 24 years and applicant one since 14 years uninterruptedly. It is the case of the respondents that their work have ever been adversely commented upon. Therefore, we find that taking into consideration the decision of the Honorable Apex Court in the case of Jago, Supra and Sripal Supra, the applicant have a right to be regularized. Accordingly, the impugn order dated so far the applicants are concerned and consequential order dated 71/23 are hereby quashed.
So what are these two orders?
Yes,
you just
this
want?
order that following. Well, what happened in this case, my lord? We are continuing for these years, whatever stated. In this order on 14/1/23, this
That is
STPI
that
has
is
directed to terminate us and it
that's-
reported it to the employer,
that
that
we
is
want
the
to-
outsourcing agent.
Hmm.
And they have issued the formal order. There was a direction that these two persons should be removed.
That order has
within
been
a month.
annexed, of course, that is
Yes,
annexure.
Convenience sake, I have prepared,
Right.
Lord.
I have got the entire copy because he has not, I have got the copies.
If the records are not there, I have prepared, for convenience sake, my lord, may I be permitted to file the copy of the OA and the counter and the rejoinder.
For passing the order dated 14/1/2023, by which the petitioners terminated the services of both the opposite party number 1 and 2, right? And also the consequential order dated 17/1/2023, by which both the opposite party number 1 and 2 were disengaged from the service.
Not, my lord, they have directed that after 1 month they will be disengaged. That stage we have gone there and we obtain a stay also. We are continuing.
Then you are continuing.
Please come to that annexure 7, annexure 5 series re se order ta ଦେଇଛନ୍ତି ସେମାନେ
ମୁଁ
17
ପଢିଉଛି, my lord. ମୁଁ repetition ଟା ଆଣିଛି, ପୁରା entire ଟା ଆଣିଛି।
ଦେଇଛନ୍ତି ପରା 36 ପେଜ ରେ
ଆଜ୍ଞା, ମୁଁ ପଢୁଛି। In
17
reference to
17/1/2023 order
14/1/23 ଟା ପ୍ରଥମେ ଦେଖ।
14/21 ରେ ତ ଆପଣଙ୍କୁ କୁହାଲା
ନା, ସେଇଟା ହଉଛି ତାଙ୍କ order, ଯୋଉଟା ସେମାନେ ଦେଇଥିଲେ।
ହଁ ସେଇ order ଟାକୁ ଆପଣ ପାଇଁ ଚ୍ୟାଲେଞ୍ଜ କଲେ।
In reference to the work order dated 14th October 2020 and subsequent extension of the work order by valid appointment order August 30, 2023, it is to be conveyed that competent authority in STPI has desired to remove following officials deployed through your agency at STPI Bhubaneswar with effect from February 13, 2023, taking into account 1 month notice with effect date of communication. Manas Ranjan, Harikrishna. These are two. Thereafter, my lord.
Just 1 minute. Se kon likhle jo annexure jota koile order dated 14/1/23
Next up, 4 to be recap.
by which 1 month notice was given to the opposite parties number 1 and 2 to terminate their services, and also the order dated 17/1/2023,
By the outsourcing agency. That is not
by
my-
which both the opposite parties were disengaged from their services
With effect from 13/2, my lord.
with effect from
Future.
13/2/2023. It seems that the Lenin Tribunal has been pleased to hold, quash both the orders, that is order dated 14/1/2023, so also 17/1/2023, and directed the petitioner to regularize the services of the opposite parties number 1 and 2 in any suitable post And in such an event, they shall be entitled to count their past services only for the purpose of counting their retirement benefits. Stop. The Stop. It was further held that the petitioner are also to pay the opposite parties, number 1 and 2, their wages oblique salary during the interregnum period when their salary oblique wages have not been paid to them. Stop. Issue notice, heard Mr. Ashok Madil and senior advocate, issue notice on the question of admission indicating therein that the matter shall get a petition, their petitioners for that. Matter shall be disposed of at the stage of admission. Mr. Samit Kumar Das and counsel has already entered appearance by filing a caveat petition for opposite parties number 1 and 2. Today he has also filed the counter affidavit
in the box.
In court, serving a copy on the land counsel for the petitioners. Stop. The counter affidavits are taken on record. So, counter affidavit is taken on record. So far as 3 and 4 are concerned, 3, 4, 5 ki appear kare. You have already filed your appearance. All right. Just a minute. Mr. Patnaik, land counsel, submits. Land and what is the designation? Senior panel counsel. Has already received the copy of the writ petition. Writ petition received the copy of the stop, and he has filed his appearance memo. Let a copy of the counter affidavit, which is filed today in court by the opposite. The copy of the counter affidavit is also served on the land and counsel for the opposite party number 3. Okay. What about this opposite party number 4, pro forma opposite party number? Opposite party number 3, pro forma opposite party number. Government of so far as opposite party number 4 is concerned, requisites for issuance of notice by speed post, proof of delivery shall be filed within a week. Matter to be listed on such and such date. Okay.
Since your records has not been called for, may I be permitted to file the copies of the OA, counter, result and everything?
Mr. Mahadil and senior advocate seeks permission of this court to file the original application.
Trial court re jaha trial court kochi lower court re jaha record
Upon the com ଅଛି ମୁଁ ତା ସବୁ ରଖିଛୁ. I also got a
The
copy.
copies of sworn sutra file court में लिख देगा. The records are, the documents are taken on record. All right. Date fix of it.
I'll leave it alone because we are not, my lord.
No, unless
me not to
the
file.
notice is issued to.
Yes, that of the private.
Baki
but
thing
formal.
nahi hai.
Hello.
If you want to file any counter affidavit, you can also file in the meantime. But that pro forma opposite party number 4, he was also a party in the, as we find.
He was not contesting.
So,
See, about that agent, that is the agency, my lord. She is not no more in. Another security agency has been employed by them.
engage them.
Now that security agency
but
changed.
he was not appearing in the for the tribunal.
Now they have changed the another security agency. That
No, that is absolutely wrong.
counter देजी visa.
Counter
All right, asun. Yes, next. ठीक है आसिफ.
কথাটা କହିଦେବେ ନା ଆପଣ ଯୋଉଥିରେ ଆপিଲ କରିବେ ଆପଣ ହିଁ କହିବେ ଆଉ କେହି କହିବେ
Next. Next item number 10.
So far as that direction that within 3 months if you do not pay, the contempt application is pending.
No. We have not. My lord have directed me specifically. You should not file. I have not filed. What is the submission?
In the last order, it was recorded.
Yes, move file करना है. I have undertaken to this honorable court.
So let it be. Therefore, I am saying that it's.
Filing the upon Yes, next. Item 10. से जो गुड़ाक जो डॉक्यूमेंट गुड़ाक फाइल करुचंदी मेमोरे लिखिबे स्पेसिफिक ओरिजिनल एप्लीकेशन काउंटर एफिडेविट रिजॉइंडर जहाँ जहाँ दउचंदी so that we will mention in the order itself हैला खाली गोटे डॉक्यूमेंट्स आर फाइल्ड सेमती लिख देले असुविधा हो ये
ताकू ये इतने गाली दोते
नेक्स्ट
May I please, Your Lordship? The petition of file, a writ application.
It will come 4 weeks, sir, because you have to file, Mr. Mahanti, the requisite is to be filed by next week. Yes, he is to file. Yes.
My Lord, the petition of file a writ application challenging the order under Annex 3 passed by the Lawrence Central Administrative Tribunal, Cuttack Bench, Cuttack.
Here also caveat petition was filed.
Yeah,
And you got
already received the copy.
Okay. So what is the prayer in this writ petition? Challenging the order of the London Tribunal dated 25/4. What order was passed? What was the prayer?
My prayer is, my Lord, the writ of
No,
mandamento.
your prayer, no. The prayer of the opposite party. Opposite party was the applicant in the before the tribunal.
There, my lord, there I was the applicant
Yeah.
and I prayed for stepping up my pay at par with my junior. My junior who has not been promoted.
The problem is that you are not filing the original application and in the order it is not mentioned what is the prayer. So that is creating us the difficulty.
Come to page 40,
Yeah.
page 40, para 14. Page 40, para 14.
Once you challenge a particular judgment of the origin, if you file the original application, counter, resender, and then the judgment, it would be very easy to go through all these and to adjudicate the case. If you don't file this, only you file the judgment, and in the judgment also we find that most of the time what was the exact prayer that is not reflected. And sometimes the counter which has been quoted, the counter may be something different. The extraction in the order may be at variance. You might be raising that this is not our objection, this is not our counter affidavit. For that, we have to see the counter affidavit.
My Lord,
But we expect when Union of India file
Right.
a petition, at least everything should
my Lord, I
be.
say one thing.
Private party
Next week, I file the.
That would be better.
Yeah.
Lekhon.
In Union of India, whenever challenges any order.
Mr. Padi is there, Mr. Padi.
Yes, my lord. So I'll instruct all the councils. they will adopt the same.
Just imagine our difficulty.
No, yes, my lord. I'm obliged, my lord.
Private
Next
party
time
we
we
can
will
understand.
instruct
They have some
all
limitation.
the councils to file all the documents. Way, counter, everything.
Right, that would be better. Lekhon.
It is better, yes.
All right. The London Council, this petition has been filed by the Union of India challenging the order dated 25/4/2024 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in way number so and so. The Mr. Saubhagya Chandra Devdas, your designation, Central Government Council.
My Lord.
And Central Government Council submits that the matter may be taken up next week or a week after. A week after, so that he will file the original application, comma,
Counter
the
and the
counter affidavit, so also the rejoinder. Rejoinder we file is jona purji.
All the relevant records will file.
Entire
All the
pleading.
relevant-
Entire.
entire records will.
The entire documents. Stop. List this matter will be commencing from 7th of July 2020. Aja, Mr. Ojha, counsel for the opposite party is present. Yes, Mr. Mahanti.
That item number 9, since your lordship had adjourned it, but that it will come after 4 weeks.
Yeah.
In the meantime, Central Administrative Tribunal records to be magazine.
ନା ଆପଣ ପୁରା ଫାଇଲ କଲେ ଆଉ କଣ ରେକର୍ଡ ଟା କଣ ହବ?
ନାଇଁ ଆଉ ଯୋଉ ଆଫିଡେଭିଟ ଫାଫିଡେଭିଟ ଗୁଡା ହେଇଛି ସେଗୁଡା ଫାଇଲ କରିନି ଖାଲି କାଉଣ୍ଟର ନାଇଁ ଇଏ କରୁଛି ଇନ କେସ୍ ଇଟ ଇଜ
So let it the other side counsel is not there, he may say
ମୁଁ ତାକୁ
something.
କହିଦେବି ଆଜ୍ଞା ରେକର୍ଡ ଟା ମଗେଇବାର
Let it be there. Mr. Mahandi, you know that he is raising something, so in absence, if any order is passed, he will take that file.
ସେଥିଲାଗି ଆଉ ଯୋଉଟା ଆଡଜର୍ନମେଣ୍ଟ ହବ
All right, it will come.
ମୋର ଲାଭ କିନ୍ତୁ ଡିଲେଡ ହବ କ୍ଷତି
Yes, next.
Item 11.
Yeah.
The two writ applications have been filed. One is challenging the order passed in the contempt petition, as well as first writ petition challenging the order passed in the way.
On 18/6/2025,
Yes, sir.
we passed the order that the personal appearance of the Director General shall not be insisted upon, right? So, who is appearing for the opposite party? You are appearing. So, what happened to that on that day when the case was posted?
Extended, date was extended. Extended regular date was extended.
Achha.
And that the case was added in view of the order of the Honorable High Court.
Now, Mr. Maharana, you are challenging the order dated 1/5/25
Yes, sir.
under Annexure 10.
But in fact,
Now-
tell your lordship, the issue is related to.
Just a minute, let us see. Yeah. You are challenging here the order dated 14/5/2019, out of which that contempt
Yes,
petition.
sir.
So 14/5/2019, then it was filed by Amulya Kumar Patnaik,
Yes, my friend is appearing.
who is the opposite party now, and you are appearing. So the other one, that is 16,389/25, এটা কোন এই ম্যাটারটা কোন এই যে
Contempt.
contempt right. All right.
Personal party that.
All right, all right.
Contempt is pending.
So what prayer was made by the opposite party?
Your lordship may kindly see. Prayer at.
That is quoted, of course.
Yes,
in
sir,
the-
that I've annexed that.
87, page 87. It's
Yes, ma'am.
quoted.
Order also quoted, I have annexed that.
The Honorable Court, Tribunal of Justice wishes to direct the respondents to extend the benefit of the order dated 3/4/2014 once so in favor of the applicant by fixing a space once.
Right.
So this was the prayer, and what order was passed by the London Central Administrative Tribunal?
Allowed the prayer.
There, paragraph number 9 is the operative part.
Yes,
Come to that.
yes, ma'am.
Page number, I think it is 91. In view of the discussion, asun to say, number paragraph.
Right. 9. In
Ah.
view of the discussion above and taking in account the consideration the fact the implementation of the order dated 3/4/2014 has been stayed by the order dated 27/5/2015 of the Honorable Delhi High Court in WPC number 5597 of 2015, Annexure R/3. Counter, we dispose of the way with direction to the respondent to allow the same benefit to the applicant in the respect of SCP scheme as granted the applicant on the OA number 1949 of 2012 in accordance with the order of the Delhi High Court in WPC number 5597 of 2012. The OA is disposed of accordingly and no order.
So similarly situated person
Right.
has got the relief before the Delhi High Court in a writ petition. That is, the number is quoted.
No, the principal bench passed an order which has been upheld by the High Court.
Right.
And the court says that you give that benefit to this gentleman. What is wrong?
Have you challenged?
It is subjudice in the apex court.
Supreme Court.
That is the sole contention.
And so, wait, let us wait.
What is the number of the?
Annex that document,
Where is that?
order also. Apex court.
That particular case was not challenged, even though they have challenged, that was dismissed for default, and it was not restored.
Maybe you also may kindly see.
Let a factual aspect, let us be clear. We are putting a question to both of you that weighed, this is a division bench order in the Delhi High Court.
Yes, ma'am.
So
It-
division
it-
bench,
Principal bench has
right.
been
So,
answered.
no, ठीक है जी, principal bench order challenge ହେଇଥିଲା writ petition रे.
Madam.
Division bench of the Delhi High Court in WPC number 5597 of 2012 has confirmed the order passed by the principal bench.
I may be corrected in that way. Principal bench allow the prayer regarding SCP to a group of persons.
Yeah.
Petitioner filed application before this tribunal, praying the same relief as you lordship gone through that order, but have been benefited given to the principal bench of the Delhi chat matter. While matter has been pending before the consideration of the authority, that has been decided to challenge before the Honorable Delhi High Court. And during the process of challenge, partially the order has been implemented by the authorities. And subsequently, the Delhi High Court has been pleased to stay the implementation of the order. But as a partial has been already implemented, that has been excluded from that order. And as similarly placed by as petitioner, some of the Delhi High Court's other application has been filed. And that has also similar care to grant the benefit which has been given to the order of the principal bench. 3 set of OAs has been filed. All have been directed as your lordship in our original application order, and that has been challenged in the High Court of the Delhi. This order, which has been disposed of by order dated 17 October 2003, that batch of case has been disposed of. Your lordship may kindly see.
So one of the, why are you making so much?
Because the
The issue in list is pending before Supreme Court, as simple as.
yes,
वर्तमान matter Supreme Court रे pending अछि,
Yes.
right?
Yes.
So हमें पचारुछु से number केते कौन order ହେଇछि, what is the stage of the case?
Come to page number 110.
110.
Come. This is the Supreme Court matter which is pending.
No.
And this matter has to await outcome of that. As simple as that.
ସେତିକି ତ କହିବେ ଏତେ କଥା କହୁଛନ୍ତି
That-
କଣ?
I am just I'm clarifying, my lord, the good
That is not there. That is
4 SLP has been filed. 4 number of SLP has
Mr.
been
Padi,
filed.
why are you complicating the list in?
No,
is-
4 number
is
is pending,
subject matter
still
to
pending.
Supreme Court
3 have a stay, 1 has a no stay. Because they already implemented there, that's why Supreme Court not interfere. Another 3 is there, pending is there.
This writ petition has been filed.
Next
By
to
the-
we will file an affidavit stating that this that the Supreme
Just
Court
a-
decision is not applicable to our case.
By the Union of India
Remotely.
and others challenging the order dated 14/5/2019 by the London Central Administrative Tribunal Cuttack Bench in OA number 40 of 2018 under Annexure 10. The London Tribunal in the operative portion has been pleased to held as follows. Quote paragraph number 9. Mr. Vishwajit Maharana, a London Senior Panel Counsel, appearing for the petitioners, submit that against the order passed by the division bench of Delhi High Court in WPC number 5597 of 2012.
15.
15.
5597 of 50.
We are really, please come to that order. We are putting a question to you and you are giving this type. You come to, what question we put to you?
5597 of 2000.
This number
12.
which has been given is 5597 of 2012, writ petition number.
Yes, sir.
But the Supreme Court order, you come to that,
10.
this is something different number.
Issue in subject is pending.
Common order has been passed.
All right.
Issue in subject is pending.
Yes.
Issue involved in this in subject is pending.
That is, there is a
Alright.
common order.
Similar orders were passed in other connected matters, including WPC number 10218 of 2015. By the order dated 17/10/2023, which is challenged before the Honorable Supreme Court in special petition, civil diary number so and so.
In that case, they have challenged, not in other case.
And
All the cases. No. You can have a glance at the order of the
All right.
Honorable Appeals Court.
Same issue is pending
Yes.
before Supreme Court.
so only this the petition number is.
Yes. Madam, this is a common judgment of Delhi High Court. All the read petition has been mentioned.
এই
And
যে 10,218, 2015,
that has been mentioned. You will also may kindly see at page
where is
93.
the order of the Delhi High Court? Let us see.
Page 93, you will also may kindly see. First dated 5597/15.
সেই নম্বরটা আছে কি আমার যে এটা করে
94 আছে 94 next you also may
90 আচ্ছা
serial number 11.
Many cases, same issue.
Same issue. Next page, my lord,
नहीं
1028 1 of 2015. Next page.
other cases से challenge होते हैं dismiss or default से restore है इन्हें और इसे
Already
we file an affidavit in that.
ঠিক আছে similar cases were disposed of and Honorable Supreme Court is in session over the matter. Notices have been issued to the other side and it has been ordered that the contempt proceeding filed before the Learning Tribunal shall remain stayed till the next date of hearing. That was the order passed on 5/8/2024. What happened to in that case?
Yes.
5/8/2024 ପରେ ନୋଟିସ ଇସ୍ୟୁ ହେଲା ଆପଣ ଦେଇଛନ୍ତି ଆନେକ୍ସର 12 ରେ
Madam.
ତାପରେ ଡେଟ୍ କେବେ ଫିକ୍ସ ଅଫ୍ ହେଲା କାରଣ ମ୍ୟାଟର was directed to be listed after 4 weeks. So whether the matter has been listed, whether any order has been subsequent, any order has been passed, ଆପଣ କିଛି information ଅଛି?
नहीं actually ମୁଁ ହେତିଲା କହୁଛି next week ରଖନ୍ତୁ
ठीक है. Let both the parties apprise this court on the next date about the status of the aforesaid special petition. Lest this matter, what a week for a proposal. 7/7/2020.
7
Supreme Court छुट्टी चलती है. So
14/7 पर
21/7 21/7/2020. We are just coming within 2 minutes.
My pleasure.
I have the instruction to appear in this case, my lord.
Which matter?
In
Well,
File your Okaratnama, give the copy of the writ petition to him.
Now
He has given it. Just a minute.
My lord, the respect information that the also it is a cover matter on the adjudication of the two cases. A similar matter in six repeats.
Avinash Swain and his associate have entered appearance for the opposite party, sole opposite party. We are filing Wakalatnama. Wakalatnama is taken on record. Land Counsel for the Union of India has already served the copy of the writ petition on the Land Counsel for the opposite party. Stop. The Land Counsel for the opposite party submits that the matter is a covered matter, and in support of such submission, he has filed the order dated 10/1/2024, passed by this division bench of this court in WPC number 43110/2023. Let a copy of the order be handed over to the Land Counsel. Ajay, copy of the order has been handed over to the Land Counsel for the Union of India in court today to seek some time to go through the same to answer to the submission made by the Land Counsel for the opposite party. Release this matter next week.
next week.
Huh?
Yes, sir.
Next week, Thursday.
It's covered or not, just see, Rafik may see.
Yes.
Well, I have gone through the Honorable Supreme Court order on the roughing mercy. That is different, my lord. I have
Just a minute.
All six cases, my lord, said in the same order.
All right, see that.
Item 13.
Yes. Kali, matter is coming for the first time.
First time.
What are you challenging?
I'm challenging the sale notice issued by the OSFC Malad by the annexure 17, announcing the sale of my factory premises.
You are challenging the order dated 13/6/25.
Advertisement and the order. Order and the ensuing advertisement.
No. Please come to the prayer portion.
Only annexure 16 is challenged.
If you want to
16.
amend the
No,
prayer,
I'll
please
amend.
amend.
I'll amend.
Please see it once again and just.
13, annexure 16.
Annexure 16, and it is mentioned that later dated 13/6/2025,
Yes.
but
This
in
is
the
letter which,
That is a request letter sent to the petitioner to participate in the auction.
this is the letter which says that we have already published the notice in the Samaj Times of India on 13/6/2025.
it is not dated 13/6, it is actually 17/6/25.
Yes,
If you come to annexure 16,
that's,
so that is how he asked us to just, if you want to challenge any other order, then please amend that.
17, no, in the top.
You see the signature also, the branch in charge signature
17.
is
So
dated 17.
Even in the top portion also they are written. The
Top,
right hand.
13 has been typed, but it has been corrected. It should have
Right
been
hand.
scrolled to, but it has been mentioned as if it is oblique.
Application, I'll file it, Manoj. I'll file it, a formal application, I'll file it.
Okay.
Can we?
Mr. Falit Land, senior advocate, appearing for the.
What will you challenge? What will you challenge? What is the consequence of after this? What happened after this? Nothing. Only advertisement. What are you going to tell?
Advertisement is posted to, the advertisement, the sale is on 5th. 5th. Now
What
the
is he going to challenge?
auction is on 5th. 5th.
We are not passing any order. We
The auction is on 5/7.
Okay.
So,
are not passing any order.
Okay.
The Mr. Falit appearing for the petitioner, 6 for an adjournment.
can we have it tomorrow?
amend the prayer portion of the writ petition. In case an interim application is filed for amendment of the prayer portion, the same shall be listed. By tomorrow you will file.
I'll file it in course of the day. You'll have to
In
call it
response.
tomorrow.
No, you file it by tomorrow. The matter will be listed day after tomorrow.
Yes.
Day after tomorrow, I'm not in
26.
town. Can we have it on 30th?
Then on
30th?
First wala.
30th of.
30th? Well, let's
Seven.
with,
Because it is already on fire. 3 साथ रची तो समय अछि. एक साथ लिस्ट कर दे.
Yes.
Interim
Along with
application-
along with WC number
If any interim
4296.
application is filed on or before 26th of June 2025, the matter be listed on 1/7/2025 with the IF.
With
Also,
another writ petition.
WPC number कौन?
4296 of 2020.
Number
4296. Great.
4296.
Appearance memo.
Okay.
Yes, is accepted. Yes.
Item 14.
Permitted to withdraw one. So, lot of permission I file a press mail.
The land council, what is your good name?
LP Dibedi.
Mr. LP Dwivedi, land council appearing for the petitioner, files a memo of withdrawal of the writ petition. Memo is taken on record. The writ petition is disposed of as withdrawn. Yes.
Item 15.
Who is not well? Who is appearing for the other side?
Yes, madam. I am not. Mr. N.R. Rautara and R.
Mention is made by Swan Sodhana Anandu on behalf of Mr. Santosh Kumar Patnaik for adjournment on the ground that Mr. Patnaik is not well. Land council appearing for the opposite party has no objection. List this matter, I would read the next.
May I pray? Since the applicant is not getting his pension, can we fix a date?
No, there is already an interim order.
Yes.
So how can, in view of the interim order, we
If
pass
the
this
date
order?
can be fixed, then
Yes, that we were fixing it. List this matter on 7th of July 2025 for them.
much obliged.
Hello? And there is an interim order on what date? Is there an interim order?
Minor. Interim order not complete.
अरे कोर्ट के भी पास है ये.
I have the
Interim order ଅଛି complete.
କିଛି ନାହିଁ ତ? ହଁ ଅଛି? All right. The interim order dated 18/12/2024 passed in IN number 13305 of 2024 continue till the next date. 7 तारीख का सुबह लिख दो. Yeah.
I beg your pardon, item 11, sir, interim order to extend.
Putri,
Item 11, that contempt matter.
11 content matter court as your second file.
Again,
Your WPC number 16389. As a key dictation नहीं तो लेकिन कोई देवे. A 16389 item number 11 ने गोटे interim order थिला. से personal appearance जो थिला ताकू ये करिया पे stay करिया पे थिला. सेटा continue करिया पे. Interim order to continue. ना?
Item 16.
Appearing in person.
Yes. Which for the other side?
I'm there on VC, Your Lordship. Today I'm actually a little unwell. That's why appearing for VC, this matter can be called some other day, Your Lordships. But last time they had their own lawyers. I also did not know that this time he's going to appear in person. Otherwise, I would
No,
not have.
he made a mention, I think, last week or what?
Yes.
Last week mentioned, and told that I will argue the matter on my own.
But then I understand he's in person, so he did not inform me. Normally, otherwise I would not have put the person in
No,
inconvenience.
it's all right. Have you not informed the land and council?
He already informed.
No, Mr. Senior advocate is made submission.
Actually, I am in team, so I'm presenting.
You
the
see, when an order was passed and you were given a date and you told to us that you will appear, you will argue the matter on your own.
No, but last time you appeared, Mr. Ratho, your appearance is there.
Said that today he is not aware that he will make the
Last time you adjourned for this room, she was there.
Yeah, because
You know,
it is running in the list actually before the petition.
This week, last hour.
last hour.
No, what I mean to say is
No.
for the opposite side.
He mentioned last week. He mentioned.
Acha, mentioning thing he is.
Mentioning.
After mentioning also, I think day before yesterday, I believe, my lawyer, they informed them that it will be listed.
Okay, you now, since both of you are there, let us tell that when we'll take up this matter.
Yeah,
Let us say, and
Since I'm from outstation, tomorrow maybe can we take in?
yes, tell us where you will be ready tomorrow.
Tomorrow, Your Lordship, if it can come 1 week thereafter. Because this actually, as I said, Your Lordship, if you see that last time he was being represented by his counsel.
So now he will argue the matter on his own.
It does not matter who is representing. Matter
And
is
obviously,
they are
therefore,
supposed to be prepared.
It's all right.
I'll have to be full-fledged prepared so that the matter is not adjourned.
If I have engaged my lawyer, she would have been ready, or they would have been ready, and since I'm appearing myself on behalf of me, and they are not ready,
you are Mr. Samant. Don't tell all those things.
No, sir,
The London senior advocate stated that she does not know that the matter will come today because you have made a mention.
Yes.
And we fixed the date because taking it will be convenient. She was not aware about it, and it has come in the supplementary list.
Okay.
So she says that one date may be given so that both of you will know.
Yes.
You are really telling something.
Yes, my lord. Yes.
At least remember that a senior advocate is telling something.
Okay.
So tell us a date.
The Lordship may call it on 5th, Your Lordships, 5th.
5th of July is a Saturday, ma'am.
4th, then I made a wrong calculation. 4th of July, Your Lordships. That will be a Friday.
Will be available on 4th.
4th of
Next week on Friday.
Friday. Why not Tuesday or Wednesday? If they are not available. If not, then Friday is okay.
Mrs. Rothor, he has some difficulty on 4th. Just tell one date.
Let it be on 2nd. That's what he said.
2nd.
Wednesday, Your Lordships.
Okay. Wednesday, 2nd. 2nd of July 2025, right?
Lordships.
Dr. Uttam Kumar Samant, the petitioner, appears in person. Ms. Pami Rothol and senior advocate appears for the opposite party. On consensus of the petitioners, who also the land senior advocate, the matter is posted to 2nd of July 2025 for final disposal.
We are from the copy number 5 and 7, but we don't have any rule.
The Land and Council, Mr. Deputy Solicitor General, Mr. Pari, along with Mr. Jagabang Mahanti, Land and Central Government Councils are present. That's me. Acha, have you not, you made a submission on that day, you have not received a copy of the writ appeal.
Yes.
And we directed that the same should be supplied to you. So have you not received it, Mr. Pari?
I don't think that copy is not still with me.
I believe we have served. If they didn't receive it, we can give them another copy by today.
Yes.
That order was
I'm
passed on. Yeah, Mr. Pari?
Yes, I didn't have a copy. There's a copy.
I'll serve the copy today, by today.
Acha. Mr. The petitioner submits that he will supply the copy of the writ appeal along with all the annexures on the Land and Council for the Union of India during course of it, right?
Obliged. Your Lordship.
Item 17.
May please, Your Lordship. Yes, that this appeal is directed against an order passed by the Honorable Single Judge, wherein a direction has been given to give all the benefits to the petitioner, that is the respondent number one, who was working as an instructor in a ITI as per the AICT scale of pay.
Mr. Samontre,
Yeah.
the noting is in the cause list that neither the AD nor answered notice returned from R1 and R2. So R1 and R2 ki hai?
Respondent number one, R2 is not state. I think.
Pranam. You are appearing with them.
State and DT.
Acha. So these are upon appear question. What about the respondent number 3?
My friend.
So all right. Come to the impugn order.
Yeah. So also you kindly come to this the order.
Annexure 3.
Annexure 3, you know. Let's here. So also see, he was the institution in question is a purely private and was.
So the writ petition was filed by respondent number 3. And what was his prayer?
Prayer is I filed the copy of the writ petition notes, that is at annexure 1. Prayer is, if you also come to page
14.
Yeah. It is therefore prayed that Your Honor may graciously please to pass necessary order to direct the opposite parties, more particularly the opposite party 3 and 4, to release the differential salaries of the petitioner as per the terms and conditions of the appointment letter, as well as the government regulation and pay scale sanctioned for the post of instructor by the All India Council for Technical Education meant for the teaching staff.
Okay. Now, what relief was granted to the opposite party number 3 by the guidance single judge?
That Your Lordship may kindly come to page 90 minutes, paragraph 25.
Please place it.
It has been observed that the scale of pay at par with the government servant of the petitioner has been revised, but the revised scale of pay under the AICT has not been released. At the same time, in the counter affidavit, the opposite party 3 and 4 have taken the stand that the petitioner is not entitled to any amount than the contractual amount mentioned in the appointment letter. In fact, from Annexure 2, it appears that the petitioner has been paid some salary at the discretion of the SMIT, but neither according to the Orissa revised scale of pay rules nor the AICT rules. So it is axiomatic to observe that the petitioner is entitled to scale of pay of the instructor as payable in the institution affiliated to AICT as claimed by the petitioner. So this court direct the opinion of 3 and 4 to fix up the pay in accordance with the AICT rules for the post of instructor from the date of his appointment, that is 85-86, till his retirement, and make disbursement of the differential salary. It is needless to say that after refixation of the salary, pensionary benefits, if any, accrued on the refixation, refix on the last pay drawn, and differential arrear amount be released to the petitioner by the opinion of 3 and 4. The entire exercise is complete within a period. Not sheer interest.
So he joined as a welding instructor on 14/10/1983. Okay.
Yeah.
And he was allowed to draw the salary and till 85-86, as it appears from the paragraph.
And there are some formal appointment order was issued. If I also look at the copy of the order of appointment.
Page 16.
Page 16, Annexure 1.
And he retired also on 31/7/2008 after attaining the age of superannuation.
Thereafter, in 2010, filed the writ application claiming benefits with the date of appointment. And his prayer is at par with the AICT. AICT is not a party to the writ petition. They filed an application to impede AICT that has been rejected by this honorable court.
This is an AIHT affiliated institute.
Courses of degree and diploma
If
are
it,
affiliated to AICT because he is in ITI, which is affiliated to NCVT Milos. National Council for Vocational Training controls the ITI courses in the state of Orissa.
All right, Mr. Samantra, please come to paragraph number 4 of that judgment.
Yeah.
What was the stand taken by the state and what was the stand taken by you in your counter affidavit?
Yeah.
So paragraph number 4 is the stand taken by the state.
For contra, on an additional standing council, honorably has opinion submitted that since repeatedly working in a private institute, the state government is not concerned in the matter to fix up the salary structure or fix the age of superintendence of the teacher as per the state government is no way concerned in payment of salary for which the writ application may be dismissed.
Okay.
And that is also in the writ appeal.
No, just a minute. Then you read what was your stand. You are the opposite parties number 3 and 4.
Yes.
What is your counter in paragraph number 5?
Mr. Milan Kangal, on a senior advocate for the opinion number 3 and 4, relying on the counter affidavit submitted that the writ application against opinion number 3 is not maintainable because it is self-financed, unaided and private professional institution for which the writ application against the institution is not warranted. In this case, he relied upon the single bench judgment of this court passed in WPC number 6990 of 2016. Prafulla Kumar Mishra of the state of Orissa and others, where his lordships observed that SMIT is not the state within the meaning of Article 12 of the Constitution. As such, the writ application is not maintained.
Now you come to the points for consideration. Paragraph number 8. Running page 79,
Yes.
internal page 6.
Point number 1 Milos.
Yeah.
There his lordships have stated that writ application is maintainable.
No, the points was whether the writ application is maintainable
Yes.
against
the
opposite
opinion of
party
three and
number
four.
3 and 4. That means against you.
Yes.
And number 2, whether he is entitled to
Annual salary on the revised scale of pay.
Now,
The
what
UGC,
was answered so far as 1 is concerned?
one is concerned, his lordship has stated that it is maintainable because that is the finding at page.
He has relied upon a number of the Honorable Court has relied upon number of decisions, including page number 9, the decision of the Honorable Supreme Court in that Anadi Mukta Sadguru, 89 Supreme Court 1607,
Yeah.
where it is stated that even if it is a private institution, if it is performing the public duty, also the writ is maintainable.
instrumentality.
With instrument. So many decisions also
Yes,
has
Lord,
been
that
relied
is
on.
true.
So to that, what is your answer?
Yes, in spite of all these, prior to this, a division bench of this whole court so say honorable single judge have observed that against SMIT itself, writ is not maintainable. I've got the judgment of
That
division
has
bench
attained
judgment.
finality.
Yes.
That has attained finality.
Yes, it has never been challenged by anybody. I've got the.
Just tell us those judgments.
Yes, so one is a single bench judgment and the other is a division bench judgment.
Just a minute.
Give the division bench.
I will give you both. I'm giving both the judgment.
In regard to SMIT.
SMIT.
Okay, did you not place those judgments before the London single judge? Or it was delivered after the this order judgment was passed?
I think
This judgment was passed by the London single judge on, let us say, on 14/3/2018.
Yes, this judgment was passed on 4/12/2019.
Okay, subsequent decision.
Yeah. And even if it is maintainable, not because AICT is not a party.
No. Writ is maintainable can or division.
No,
Why we will say writ is maintainable?
No, I'm not saying. I'm saying that even if the writ is maintainable.
Stick to your point, Mr.
So that will also point.
Stick to your point. Once the division bench has held that it is
Yes.
not maintainable and it has not been challenged also. Whether this was this specifically, it was held like they were discussed and held, or it was just a simple.
No, if you also kindly come to the division bench order me lost. If you also see.
What is this, Judge?
This was not, no discussion. This is just a formally, it is observed.
Where is the reasoning?
There is no reason.
Where Article 12 is not considered,
No,
nothing is considered.
but how?
This is not a binding.
No.
There is no ratio decision.
Once you see sweeping observation
Yeah.
that rate is not maintainable without
Yeah.
any reason. We are,
No, so I
when the Learned Single Judge has
Considered
quoted
all
the
this,
number of
right.
decisions of the
Right.
Honorable
No, it's
Supreme
only
Court.
possessive value. Milord.
That's the
Only
reason
because
you,
the
that's the
judgment is held.
reason, that's the reason even if
Yes.
you said, even if it is not maintainable. That's the reason he knows it.
Go.
Okay.
Now, what is your ground in the writ appeal? Let us see.
The grounds is that, Milord, this is one ground. Second ground is that, Milord, it's a purely unaided private educational institution, Milord. And he was working as an instructor in a ITI institution, Milord, which is not affiliated to AICT, rather it is affiliated to NCBT, that is National Council for Vocational Training, which controls the courses and management.
No. We are posing a pertinent question.
Yeah.
The two issues you have framed.
Yeah.
Both the issues were answered in favor of the
Which are-
opposite party. I mean to the present opposite party.
Respond
was the
number three,
petition. Have you taken any ground that the finding of the Learned Single Judge
Yeah.
that writ is maintainable against you
Yeah.
is erroneous? Have you taken such ground?
Yes, in the appeal, Milord.
Yes.
Yes.
Where is that
Yeah,
ground?
also may kindly come to.
And your own point, which you have taken before the writ court, single judge,
Yeah.
itself suggests that AICT is not a necessary party, or neither necessary nor proper party. Come to page 86.
Yes, only because.
Then rightly his application is rejected
No,
for
why I said that, because we are controlled by NCBT, not AICT.
That's right. The AICT is not a necessary party.
But his prayer is for as per AICT. So he should have said that because I prayed for a relief. as per
Once,
the-
Mr. Kanungo, it's a
Yeah,
writ appeal.
Yeah.
And you are not taking specific ground to challenge that particular finding of the Learned Single Judge that writ is maintainable against your institution. How can you advance such a point at this stage? Neither you have taken such point in your counter affidavit filed before the Learned in the writ petition, nor you are taking that as a ground in the writ appeal.
No.
And you are producing before the order of two sweeping observation, we can say, that writ is not maintainable. How can we entertain
No,
such a submission?
Before the Honorable Singh Judge, I had taken a plea that writ is not maintainable. That was the ground, but here no specific ground, Milord, I think.
Leave that point, then come to the second one.
Yes, Milord.
Yes.
Because losses is, direction is given to pay the scale of pay as per the AICT guidelines, Milord.
Come to that, to why the Learned Single Judge has passed such order. What is the reason behind it?
Milord. Point number 2, page number 86.
Yeah.
Learned Counsel for the petitioner submitted that the institution of the OP number 3 and 4 is affiliated to AICT and the petitioner was appointed in that institution. On the other hand, Learned Counsel for the OP number 3 asserted that OP number 3 have got two streams. One is degree, technical, and the other is diploma courses. Degree courses are affiliated to AICT, whereas diploma courses are affiliated to NCBT. Learned Counsel for the OP party 3 and 4 could not place any sort of material to show that diploma courses are affiliated and controlled by the NCBT. On the other hand, the petitioner filed the brochure of the institution for the session 88-89, where the diploma engineering wing is under AICT because it has submitted information to AICT through DTET Orissa. It is needless to say that the petitioner was appointed as instructor in diploma engineering course. Thus, it must be observed that the petitioner joined the SMIT, which is affiliated to AICT. It's not engineering diploma, Milord. It's only ITI. So ITI is, Milord, obviously affiliated to NCBT, Milord.
Paper 18.
Yeah.
Per 18.
Come to the appointment letter.
The appointment letter, our officer, Subhash Chandra Mishra, engineering Barampur, is appointed as welder instructor and remain in charge of fabrication in the scale of a certain per month with the usual D and age admissible to government servants.
Age admissible to the government servant of Orissa, and
Yes.
thereafter the appointment is temporary.
Yes.
That is what the single judge has analyzed.
But ACT, their scale up is different. It is applicable to teaching staff. He is not a teaching staff. He is an instructor. That is the question.
He is a faculty member. He is a faculty member.
A faculty, but it's an instructor, not a teaching staff, because I have also given the document of the ACT guideline or annex it. If you also look at annex 4, ACT guidelines says which are the courses affiliated to it. And it is given the detailed guidelines, how they are to be appointed, what should be there.
Please place that from paragraph number 19 onwards.
Yes, sir. Yeah. From the aforesaid office order, it is clear that the petitioner was appointed as instructor welding and remained in charge of fabrication with scale of pay with the DA and ADA admissible to government servants of Orissa. There is nothing found from this order that the petitioner was appointed for a fixed period with consolidated amount of salary as claimed by the opposite parties 3 and 4 in their counter affidavits. Moreover, the service book as placed by the petitioner and the opposite parties 3 and 4 clearly shows that the service book as maintained for government servant has been followed by the OP number 3 and 4. When the service book is maintained and appointment letter is clear to show that the scale of pay as admission to government servants should be made available to the petitioner, the court is of the opinion that the petitioner is a regular employee and he was receiving salary as government employee. The copy of the service book also shows that the petitioner has been given annual increments time to time and the service has been verified from time to time as per the procedure applicable in government service. Besides this, the petitioner has been allowed revised scale of pay with effect from 1/1/2006, and also it appears that on attaining the age of superannuation was relieved from duties on 31/7/2008. When the service book is maintained showing revision of scale and on the date of superannuation he was allowed to retire, the contention of the learned counsel for the opinion 3 that the petitioner was paid consolidated pay and the job was temporary one is untenable. It is considered by the counsel for the opposite parties 3 and 4 that SMIT being self-financed meets the requirement of staff from its own source. It is also submitted that the claim of the petitioner for payment of arrear salary should not be allowed as the opposite parties 3 and 4 never pay the salary to its employee as per the government servant employee. When the office order shows that the payment of salary is made as available to the government servant and the revision of the scale of pay have been made as per the revision of scale of pay rules either in 1998 or 2008 passed by under the state government. The contention of the council for 3 and 4 that it has no obligation to pay any amount at par with the government servant is irresponsible, inapposite. In view of the aforesaid analysis, this court is of the view that the petitioner is not only entitled to scale of pay at par with the government employees as per the Orissa revised scale of pay rules framed from time to time, but also entitled to receive the same under the ACT as the Institute of University is affiliated to ACT. Accordingly, it has been directed.
Is there a difference between AICT scale and state government scale? State government scale?
Because they are the teaching staff. Here it is their instructors, not they're not called as faculty members, they are only instructors, who they guide the students during this training only.
Like laboratory assistants. And
Exactly,
Yes, so what is your submission? Any other thing you want to say, Mr. Samantray?
This is my, because I say, if even the, sir, OP number 2, the Director of Technical Education and Training has filed an affidavit before this one in the writ appeal saying that because it's a purely private institution, we have got nothing to say so far as salary of the respondent number 3 is concerned, because we are not involved. That was received by me. I think it must be on record. Of course, they have filed a counter affidavit on behalf of OP number 6, they have written it, but it should be OP number, respondent number 6. 6 it should be record number 2.
No, the entire record is with us and the scanned copy is available. Also.
The affidavit has been filed by one Sir Brajendra Narayan Rautray.
948 hour ko no? You the writ petition you connected it as writ petition, counter affidavit, additional affidavit file aging.
Like,
by opposite party.
It has a writ appeal resolution.
Oh, writ appeal.
Exactly. Writ appeal wrongly they have stated that counter affidavit on that is dated 10/5/2018.
No, that is available.
Yes.
But it is mentioned as counter affidavit on behalf of opposite party number 6.
Yes, that is wrongly, but it is the respondent number 2. He is the director, deputy director TT in the office of the DCET. And he says that authorized by the open on their behalf present return, I am not well accounted wrongly mentioned, but they say paragraph 6, 4, 5, 6, they stated that it's a purely private unaided educational institution. We have got no control over it, and it's a salary component is a dispute between the management of SMIT and the petitioner respondent.
Who is this opposite party number 6? Is the
no 6 no. Sir, who the 6 like look at the respondent number 2, Director of Technical Education and Training, which controls the diploma, the IT courses in the state of Odisha.
deputy director.
Deputy Director filed this affidavit.
Deputy director was a party in the writ petition.
No, on behalf of, he has filed it on behalf of respondent 1 and 2. He has mentioned it in that affidavit. Paragraph 1. I've been duly authorized by the office 1 and 2 to swear this affidavit on their behalf at the present.
No. What was the stand taken in the counter affidavit filed by the other side?
They said that it's the same thing. They said that writ petition is divided by it because they said that it's a private institution.
Have you filed that counter affidavit?
Oh, no, I filed my counter affidavit because they're on record.
No, the counter affidavit along with the additional counter affidavit, that is from page number 33 to 70.
That is my counter and the additional counter.
So who else has filed the counter affidavit in the
state? They must have filed counter affidavit.
But it's not there in the record.
It must be in the WPC record.
The WPC record is not there.
No, it has been under.
No, it is there, but the counter is not there. No, it is there. Counter is there. Opposite party, yes.
Opposite party number
1 and 2.
Paragraph 4.
Gyanaranjan Roy is filed.
Gyanaranjan Roy.
Yes.
Yes. What do you say?
There are 2 points.
Yes.
You have to answer.
Yes.
The first point is the institution may be affiliated to AICT.
Yes.
But the course for which you are the appointed as an instructor was not affiliated to AICT. It was affiliated to NGBT. This is one thing. Second, the Unikrishna judgment says beyond 3 years you can ask for the arrears. And the judgment says that give the arrears because 2008 you are retired and 2010 you are filing the return.
Up to retirement, my lord.
After retirement, 2 years after retirement you file.
I have also filed.
See, you filed the writ petition on 16/7/2010, whereas you retired on 31/7/2008.
For gratuity, my lord, I have also filed an writ appeal that has been already decided on 2019. Kindly have a glance, my lord. In gratuity also they have given writ appeal I have filed.
Counter stand कौन नहीं चंदी दी जन जगह है not affiliated
Not
to.
affiliated.
Yes.
Not affiliated. That's very
Our
specific.
stand, our stand specific is that this course is not ITA course is affiliated to NCBT, not ASCB.
My lord, in ITA, what you have stated, nowhere it has been stated that I am teaching for ITA. No, in the appointment letter. kindly have a
Appointment
glance.
letter does have, of course, sir.
In appointment letter, what post they have stated that has been diploma and
annexure 1 टा होची आपन appointment letter.
appointment letter.
That होची writ petition annexure 1
Kindly have a
and it is mentioned that you are appointed as a
And-
welder inspector.
Yes,
Instructor, sorry.
Yes.
And remain in charge of fabrication in the scale of pay of so and so.
Yes.
With usual DA and ADA as administrative to the government servants of home.
And then he should come with
Communicate.
welding transfer.
Holding the
Which will be not given to him. So most of welding instructor is
holding instructor is also a diploma in diploma course. It is holding instructor post is there. In appointment letter, copy to accounts officer, principal, diploma, and workshop superintendent.
How NCVT is defining this instructor post?
No,
yes.
NCBT, their
Where is-
new stand they have taken.
Where is that? No, not new stand. They have been saying that it is affiliated to NCVT, not AICT. But how NCVT is describing this post? Is it a teaching staff or non-teaching staff? What is that?
So
They have not.
I've given the AICT because of AICT guideline I've given here.
But where is the NCVT
I
guideline?
will get it, Milos. I will get it.
Unless you see that, how can you,
I understand. I will get the NCVT guidelines, which are the posts, Milos, whether it is
whether this post is covered under NCVT or not, how will you know that?
I will get it, Milos. I will get it or also call it because the direction was given to give as per the AICT guideline. I filed the guidelines of the AICT.
But your stand is it is NCVT, then
Yes.
you have to place it and say that under this provision of NCVT, this post is covered.
Yeah, I will get that, Milos. So also give me some time only. I can get that NCVT guideline, Milos.
That was not placed before single judge.
Yes, Milos.
That was placed before the single judgment.
Mm-hmm.
They have stated that the post is for NCBT. But they,
That's right, but NCVT,
they have not
it
produced
was
any
not placed.
scrap of paper about the NCBT in the writ court, my lord.
Is it now open for us to look into look into document which was not placed before the honorable judge?
Seven, I can file your lordship can, my lordship may, because it is appeal, it is open for you to accept. Of course, it's not binding, but your lordship can order 41 rule 27 will be applicable to this appeal.
You think this, suitor?
What is the financial implication? How much?
What more, my lord?
How much you tell me?
Well, I will calculate. One thing.
You calculate, you must know it. Much more is not the answer. Then we will put in Unni Krishna confine it to 3 years.
Lordship, they've given a calculation 7,97,389.
7 lakh, very big amount for you.
No, obviously not, lordship, no. No, state government also we could have paid. Because in state government ITIs, they are getting at par with the scale up we have given.
So as Unni Krishna judgment.
Sir, I'll get it, plus. I will also take instruction lords with regard to.
All right, we are reserving the order and you produce that by Monday you do.
NCT guideline.
No, you file a written submission, both of you file your written submission and along with the judgment. Unni Krishna also you file, highlighting that portion.
If you also grant with also liberty or second file the NCT guideline, should I file it?
Yes, you file along with the written submission.
The hard Mr. Ratindra Samantra, Land Council appearing for the appellant. The Mr. Parthasarathi Naik, Land Additional Government Advocate for the opposite party respondents number 1 and 2, no?
1 and 2.
2 and Mr. Mahanti, Land Council appearing for respondent number 3, right?
Yes.
Stop. The impugned order is input judgment and order is dated 14/3/2018, passed by the Land and Single Judge in WPC number 9492 of 2010. And it seems that 2 points have been formulated by the Land and Single Judge, which are quoted in paragraph number 8. And while adjudicating the maintainability of the writ petition, the Land and Single Judge has taken into account the various decisions of the Honorable Supreme Court and held that the petitioners are amenable to writ jurisdiction of this court, although it is not coming under the definition of state as per Article 12 of the Constitution. Stop. Mr. Samantrai has filed the 2 orders of this court. One is by the division bench in OGC number 4482 of 1999, and another by the learned single judge in WPC number 6990 of 2016, where a sweeping observation has been made that the petitioner's institution is not state within the meaning and ambit of Article 12 of the Constitution, and as such, writ petition is not maintainable. The orders are taken on record.
We find no ratio recently from the.
However, we find that no reasons have been assigned in the aforesaid two orders for holding that the petitioner's institution is not amenable to writ jurisdiction. And though at the outset, Mr. Samantray raised such a submission, but on perusal of the grounds taken in the writ appeal, we find that there is no challenge to the findings of the learned single judge in holding that the petitioner's institutions are amenable to the writ jurisdiction of this court. Stop. The only point remains to be decided in this writ appeal whether the petitioner, whether the opposite party number 3 is entitled to the arrear salary under the revised scale of pay as per UGC or AICT guidelines. Stop. The learned counsel for the petitioner, opposite party respondent number 3 has filed an order passed by the division bench of this court dated 10/11/2022, passed in writ appeal number 2022 of 2019, in which the opposite party, in which the respondent number 3 was the appellant, and his prayer for what was the prayer made in that?
For payment of gratuity.
For payment of gratuity was allowed. The order is taken on record. After hearing the learned counsel for the respective parties, the hearing is closed. Judgment is reserved. The learned counsel for the respective parties is at liberty to file their written note of submission by 30th of June 2025. All right.
Along with the relied upon judgment.
Along with the
That payment of gratuity, that is under a specific act, and against that, I think.
Therefore, we are saying that along with the relied upon judgments.
Yeah. And so far, now the judgment of my friend was mostly appearing for the central government, NCBT, You must be aware of all these things.
Whatever you want to,
But in this case, he is silent spectator. He has said already.
ये तो चुपचाप रही गले आप फाइल करूँ तो जहाँ फाइल करे आगे तो फाइल मान जाओ that's all.
Pardon to mention item 30
Mr.
in
Pratham,
item number 18 next item.
ये तो सब काली आसीबो ना
Kali 30 re we will permit to take up it at an earlier stage. In your
काली to earliest date कौन नहीं पारे
sir काली थिला जो सीरियल आज से सीरियल अछि
काली का पड़िबा मैटर फस जाउची हमको
काली भी पड़िबो
but it will not we assure you that it will not go out of the list that much we can
no do so how sir
a hearing matter
maybe to make a mention in the first hour because in
you make a mention all these matters will be left over
the case will be go to DRT only
Be positive for tomorrow.
tomorrow पण आपण माने जेते बेले आसीबे मेंशन कर देबे
नंबर दिया नंबर देइथिली फाइलटा आसीची
अरे फर्स्ट आवर मेंशन करिवे नले आफ्टर लंच मेंशन करिवे एटे उठना
बेंच नहीं
ए आपण बेंच नाही बिले की कहला
काली फर्स्ट आवर करियो
पार्टनर सीनियर is आपके
want to make mention. Criminal appeal, I filed IF for bail minor.
Yes, you.
Two appeal bail.
You want to?
Supplemental list, item number 1.
Wait, please, yeah. The appellant has been sentenced for life, Your Lordship. For the offense under section 302 IPC, Your Lordship. Fine amount that I have to pay is 10,000.
Or admit call for the prior court record. Interim applications for bail and stay relation of fine to be considered after receipt of the prior court record. Deposition copies to be supplied to the land counsel for the state. Yes.
Item 2.
Yes, Mr. Samudra.
I filed IF for bail minor.
You are appearing in both the matters.
No, second matter, I am appealing your. This is thing that converted to CRL. And the first matter, I am appealing for the informant. The first matter, I am appealing for the informant.
58 of 2015.
Yes.
But your Wakalatnama is not there, so your name is not there.
I have filed my Wakalatnama earlier, it was there, my name was appearing.
If 58 of 2015, ne?
Yes.
Wakalatnama tha.
If the there is the Wakalatnama similar, it was filed on 29/3/2017.
No. ये अपन ब्रीफ ऊपर भी अपन ना नहीं तेणु वकालतनामा टोटाल एटा तो डिक्रीज डाउन करो वकालतनामा अच्छी बाहर करो देखो केबे फाइल करछन कहउछन
29/3/2017.
29/3/2017. Imagine. Vishwajit Nayango Nartu. No. Upon Parashi, for fight for the or misspecific or Wow. While another Wakalatama, it is not there in the column. Is it there? Nine, all right. So, your first item, 58 of 2015, Mr. Vishwajit Nayak, Land Council submits that he has instruction to appear for the Wakalatnama, for the informant, and he will file Wakalatnama by next week. All right. Mr. Samantra, so what is the offense and there are
Present appellant found guilty for the commission of the offense under section 302, 49, 34 and 324 of the Indian Penal Code number, and convicted thereon and sentenced for life and to pay fine 5,000 million.
So since when you are in custody?
Custody since 14/3/2012.
Your bail application was rejected earlier.
My.
By which order? So it is rejected on 6/2/2023. Okay. That is.
Yeah.
And,
Custody certificate.
You are granted interim bail by the order dated 26/11/24. For what period you are granted?
Period of
Marriage ପାଇଁ ଯାଇଥିଲେ.
15 days. Surrender on 5 also.
2 weeks ପାଇଁ ଯାଇଥିଲେ. You surrendered, huh? So is there any that custody certificate is available with you?
No, ma'am.
And what is the instruction? What about the criminal antecedents and also his conduct during this 15 days interim bail period? That you obtained in the meantime, huh? The Mr. Samantrayal and counsel appearing for the appellant submits that the petitioner was taken into judicial custody on 14/3/2012 and his bail application was rejected earlier in this appeal on 6/2/2023 and by order dated 26/11/2024 he was granted interim bail for a period of 2 weeks. 2 weeks, no? 2 weeks for the marriage of his younger brother, and after availing the same, he surrendered at right time. Stop. Let the land and counsel for the state produce the custody certificate of the petitioner and also take instruction about the criminal antecedents, if any, against the petitioner, so also his conduct during the interim bail period. Put up this matter in the week commencing from 7th of July 2025 with CRL number 45 of 2019.
There is no criminal antecedent.
Let him open. And Mr. Naik, you in the meantime file that, huh? No.
Item 3.
Plan to undergo for life to pay 10,000 each default. They will undergo further rigorous imprisonment for 1 year. Acting
What is your good name, Land and Counsel?
Gagan Bear Singh.
It is a sole appellant.
Right.
Huh?
Right.
How many appellants are there?
3 appellants.
3 appellants. So what happened to you are filing bail application for whom? This bail application which you have filed, that is miscase number, IN number 25434 of 2024. It is filed for all the appellants or all the appellants. But the cause list indicates that a petition has been received from the jail to engage Mr. Saurachandra Mahapatra in place of Devasnan Das. And in the meantime, SK Naik 2 and associates have filed Wakalatnama on behalf of appellants number 1, 2, 3 respectively by taking consent from previously engaged counsel. So when the order was passed, who is to conduct the case? ଆପଣ କଣ ଓକାଲତନାମା ଫାଇଲ କରିଛନ୍ତି ନା କଣ? SK ନାୟକଙ୍କର ଓକାଲତନାମାରେ ଆପଣଙ୍କର ଅଛି। So the prisoner's petition, when that prisoner's petition was received? At flag D. That's an old one, 2017. D, E, ଏଇଟା କେବେ ଦେଲା? ସେ 2023 ର। ଏଫଟା ହଉଛି 2023 ର। ସେ ସବୁ ତିନିଟା ଆଗରେ ସୌରୀ ମହାପାତ୍ରଙ୍କୁ କହିଥିଲି ଆପଣଙ୍କର ଓକାଲତନାମା କେବେ କାରଣ ଫାଇଲ କରିଛନ୍ତି? 24 latest one. अच्छा, right. और एक बार लिखी दियो दो prisoners petitions have been received at which is at flag D, E, and F from the 3 appellants to engage Mr. Sorochandra Mahapatra and senior advocate as their counsel in place of Mr. Devasnan Das, but the petitioners are dated 26/4/2017, 16/10/2023 and 21/10/2023. However, Wakalatnama has been filed by the 3 appellants in favor of Mr. SK Naik 2 and his associates, which is dated 3/10/2024. Therefore, we are accepting the Wakalatnama filed by SK Naik 2 and his associates as the advocates for the appellants. The name of Mr. Devasnan Das and his associates, so also Mr. Sorochandra Mahapatra, shall not be reflected in the cause list henceforth. Yes, argue the matter.
Appellants are in custody since 29/6/2012.
Yeah, your bail application was earlier rejected.
Earlier ones earlier rejected.
When it was rejected?
2015.
2015?
No.
No, you are not correct.
6/10/16.
6/10/2016.
1610.
That was filed by appellant number 2 and 3. Okay, particularly 26 report ये partitive form करिए 26/10/2016 A2 A3 then
Insofar as 1 is concerned, it was never rejected. Appellant number 1.
Appellant number 1.
1 was never rejected.
Rabindra.
No.
It was never rejected. So 2 and 3 were rejected. Now you are in custody. All 3 were taken into judicial custody on one day.
No, my lord, Rabindra, appellant number 1,
Yes.
custody in 29/6/12.
A129.
6, 2012.
Okay. What about A2?
My lord, 4, 7, 2012 and 5, 7, 2012.
4, 7, 2012.
My lord,
Now A3 टा केवे?
5, 7, 2012.
5, 7, 2012. Okay. Now, you are not on bail during trial.
No.
So, it's a case under section 302.
My lord.
So also under section 307. So you are found guilty under what offense?
My lord, 302 and 34 IPC.
307 charge was disbelief.
But the sentence, there are not 302 million. Punishment.
Oh, you are not found not guilty. Prosecution has successfully proved the charges under section 302 by 34 against Ravindra Swanso, not prove the charge under section Swanso or any allegation. So, who is the deceased?
My lord, this is Satmita Malik.
What is the date of occurrence?
Date of occurrence, my lord, of 15/5/2012.
Eyewitnesses are there.
My eyewitness.
Who is the eyewitness?
You know, 6, 7 and 10.
My
6.
7 and
7 and
10.
10.
Who is the doctor who conducted PM?
Doctor and people.
So, come to the evidence of the doctor first. You have assaulted a lady and external injuries indicate one number of symptoms. Lacerations, confusion, spinal cord injury and its complications. What is the weapon of offense according to the eyewitness?
Eyewitness Ravindra Malik was holding a thenga blow and kick blow.
PW
Iron rod.
6.
6. Head injury.
Come to PW 6. Accused persons assaulted. He is the husband of the deceased. So one of them was holding thenga, the other two are iron rods. Accused persons assaulted on the legs of my wife. Gangadhar assaulted my wife by kick blows on her belly. Then Ravi assaulted my wife by big and thick thenga on his head, for which she fell down unconscious. He sustained bleeding injury on the head and other parts of the body. So, 11, the doctor has also, when the deceased died actually, death took place when? Because the postmortem report indicates that the PM was conducted on 16/7/2012. It is almost after 2 months of the assault. So when she died,
Mr. Pradhan. Occurrence on 15/5/2012 ठीक तो?
Secretary ଅପରାଧ ଗୋପୀନାଥ 15/6/2012
15/5 କହିଲେ FIR ଟା କହିଥିଲେ trial court order
56.
नहीं 15/5 लिखा है the date of occurrence is 15/5/2012
15/6.
no come to the charge
PW6.
charge
PW6 says that the occurrence took place on 15/6/2012 at 9 AM.
charge that's wrong charge लिखा है 15/5/2012 रे घटना हला FIR टा केबे लॉज हिची
PW7 also says 15/6.
FIR लॉज हिची
16/6.
16/6 मासे पर FIR हिची एवं घटना एथिरे मध्य कहउछन्ती मु आज 16/5/2012 तारीख रे थाना रे हाजर होई ए इतला देउची कि गतकाली अर्थात 15/5/2012
What is then? All the witnesses have said 15/6. PW6 just see, PW7 see, PW12.
FIR mentioned that 16/5/2012.
15/5 15/5 এবং ए चार्ज रे मध्य 15/5 लिखा है
Witnesses go to the court.
कारण FIR लॉज हिची 16/6/2012 एठी मध्य FIR देखुची डेट ऑफ ऑकरेंस होची 15/6/2012 किंतु पूर्ण लिखी कोटा लिखी बोल
died on 15/7/2012
सही तो
died on 15/7/2012
16 मासे परे मरची प्रा माने यदि सेई डेट को FIR डेट को ये करा जाए कारण से लिखुची FIR रे जे गतकाली सकाळ 9टा रे मो स्त्री ट्यूबवेल को जाउथिला बेले हठात ए माने आसी ताकू मारिले तापरे ताकू आमे नै गलु कुजंग डाक्तरखाना को कुजंग डाक्तर बाबू परामर्श देले कटक डाक्तरखाना को नै जाओ कटक डाक्तरखाना रे मोर स्त्री मृत्यु सहित संग्राम करूची ए एतलाटा दिया हिची एठी मध्य लेखा हिची 16/5/2012 IAC सिग्नेचर अछि यू गॉट इट
नहीं सब सारे witness go to the PW10 also says the occurrence took place on 15/6/2012 on the day when the Raja Sankranti is at about 10 AM. PW10 also says, 7 also says, 6 also says.
some confusion it is 16 over 16/6 15/6 घटना हिची so it is not 15/5 15/6/2012 तो मासक परे ये कला मला से तो ये जो आपनकर आई विटनेस आसिले ओवरटैक्ट का ना आसुची स्पेसिफिक
Serial list exhibit 1. That time it was 307. Okay, 307. 16/6/2000.
नहीं देख सकते से भूल ले लिखी जे
16/6
जो इत्तला करी ये देइछि से लिखि देइछि भूल ले 15/5 ले लिखाई इत्तला रे गंगाधर
but in the FIR in the top it is written 16/6. Yes. FIR
Come to the next page.
Next page it is.
Check them.
It is all of.
It is.
It is all of लिखी but it is correctly.
Sir.
It is correctly.
Let us look, sir.
So it is 16.6.
So that period, if it is calculated, then is in custody, they are in custody for about 13 years.
Yes, this is the custody certificate. Certificate to custody of Ravindra. It is on 23 days. And she's 10 years, 5 months, 28 days. 24. These are 24. Oh.
Are the Land and Counsel for the petitioners and counsel for the state. Land Counsel for the petition submits that petitioner that appellant number 1 was taken into judicial custody on 29/6/2012. Appellant number 2 का नाम लिखूंगा on 4/7/2012 and appellant number 3 on 5/7/2012. Final form का बाहर कल देखते हो स्टेटमेंट है जो custody date. ठीक. And they were never released on bail during trial. And as such, they have remained in judicial custody for more than 12 years. When counsel submits that since there is no chance of early hearing of the criminal appeal, the bail application may be favorably considered. Land Counsel for the state, on the other hand, submits that the prayer for bail of appellant number 2 and 3 was rejected by this court in this criminal appeal on 26/10/2016. And 3 eyewitnesses, that is PW 6, 7, and 20, have stated about the participation. PW 6, 7, and 10 have stated about the participation of the appellant in the assault of the deceased Susmita Malik on 15/6/2012, for which she was undergoing treatment in SCB Medical College Hospital and expired on 16/7/2012. Considering the submission made by the Land Counsel for the respective parties, in view of the available material on record, particularly the statements of the eyewitnesses, so also the evidence of the doctor bracketed PW 11 who conducted post-mortem examination, while not inclining to release the petitioners on bail on merit but taking into account their period of detention in judicial custody and absence of any chance of early hearing of the appeal in the near future, and further taking into account the ratio laid down in the case of Leti versus so we are inclined to release the petitioners on interim dates for a period of 3 months. Please this matter on such and such date. Yes, next.
Is there any dying degree in this case? Dying degree is like that.
Next.
Item 4.
So for you, Lasik, after granted in interim bail, director room to surrender before 15/5/2025.
Surrender.
Where is the certificate?
May I please, Your Lordship, I'm appearing to virtual mode, Your Lordship, in the connected appeal, Your Lordship, 419 of 2019.
Okay, we'll hear you just.
Yes, Your Lordship.
Criminal appeal number 88 of 2019. Mr. Das Paridal and counsel appealing for the appellant submits that after availing the interim bail period as per order dated 29/4/2025 passed in IN number 995 of 2025, the appellant has already surrendered and in the trial court and he is now in judicial custody. Surrender certificate has been filed, which is taken on record. Stop. Yes. What do you want now?
Taken this matter, one week after.
So what is this interim bail again you have filed? So, IN number 1085 of 2024. The London Council, ये 16 appellant था?
488 में 16 appellant.
हाँ, एगुड़ाक सब आपना not press करे उजाऊँ
Yes, sir.
IN number P16 of 2021, IN number 1085 of 2024, IN number 2475 of 2024. These three applications for bail, the London Council for the appellant doesn't want to praise these applications. Accordingly, it Indago IA disposed the as not praised. Surrender certificate filed. Yes, connected matter is 419 of 2019. Madam, कौन question दी?
Your Lordship, wide IN number 1261 of 2025, Your Lordship was pleased to grant interim bail for 4 weeks in order to appear in marriage ceremony of his son, Your Lordship. In the meantime, the appellant has already surrendered on 3/6/2025.
Where is the surrender certificate?
We have filed it today. Filing.
Same order. He was directed to be released on interim bail. Second item. That is 419. Huh? For a period of at a 419, at a 88. 419 now. By order dated 6/5/2025. And traveling the surrender is like the surrender certificate which is taken on record. Okay, madam, there are other interim applications which were filed in 2019-24. What do you say about those applications?
Lordship, those are not praised, Your Lordship.
Okay, take on IN number you would have achieved 1000 of 2019 as well as 308 of 24. These are the applications for bail. Land Council for the appellant does not want to praise the applications. There is an application for stay of realization of fine. It is allowed. Stay of fine. Okay, next item number.
Item 5.
5 minutes. After that is the council obtaining the certificate and the implementation of the appellant.
Yes, I will tell have a class order dated 12/8/2024. On merit, the bail application of the petitioner was rejected.
Kebe rejected ji?
12/8/2024.
The order dated 25/4/25.
That was not brought to lordship's notice.
He was an absconder.
Yes,
and there are
during the period he also committed another offense.
One of the case was prior to the commission of the crime in question. 2 cases were instituted while the petitioner was in jail in this case, and the 4th case is with regard to an offense which the petitioner committed while on parole. So all these things have been taken into account And apart from your
Evidence of freedom
identification,
13,
by freedom 13.
Pardon. While that's good, that solution merits. While in parallel, in that case, he has been acquitted.
that is different.
You'll also, that's a conference, take instruction and other antecedent. So far as other antecedent is concerned, all the allegations, so far as against the family member, while he is judicial custody.
Whatever it may be, it was rejected on merit on 12/8/2024.
And
So what is the change in the circumstance was to consider afresh, even prior to passing of just 1 year being. ବୁଝିପାରୁଛନ୍ତି ତ ସେଇଥିପାଇଁ ଆମେ ପଚାରୁଛୁ
ସମସ୍ତେ ବେଲରେ ବି ଯାଇଛନ୍ତି.
The petition is absconded.
We are not.
This petition absconded from Nagpur after 1 year.
Four cases are there against you apart from this case under section 302. And you absconded while being granted bail. You in parole you committed one offense.
मतलब जो parole ହେଇଛି ସେଇଟା
jail ରେ ଥାଇକିନା ଆଉ ଦିଟା
ସେଇଟା ସେ ଯୋଉ କରୁଛନ୍ତି ସେଥିରେ acquittal ହେଇଛନ୍ତି. jail ରେ ଥାଇ ଯୋଉ ଧମକିଛନ୍ତି ସାକ୍ଷୀ ସେଥିରେ acquittal ହେଇଛନ୍ତି.
Produce those orders. Lecon, the Canon Counsel for the appellant submits. So and so is present. Mr. Robert appears for the informant, and Mr. Nayak appears for the state, and the Canon Counsel. Submits.
I will file a comprehensive affidavit to that effect.
So in the rejection order dated 12/8/2024, passed in IN number 1463 of 2019, it is stated that apart from the case, there were 4 other cases instituted against the petitioner. But he has received instruction that in all those cases,
not all,
in some of the cases, the petitioner has been acquitted and he intends to file a comprehensive affidavit to that effect, annexing the judgment of acquittal put of this matter on such and such date. Yes.
I just clarify. जो चारिटा केस अछि से गोटे केस
ଯାହା କରିବେ ଆପଣ ଲେଖିକିନି ଦିଅନ୍ତୁ କଣ comprehensive affidavit କଣ ଆଜି ହେଇଯାଉଛି ନା. Yes, next. Yes, item number 6.
Item number 6 was directed to serve the copy of the brief on the informant and the commissioner of all. It was served yesterday only.
Yesterday you served.
So notice was served, it is a POCSO case. Notice was supposed to be served upon the informant.
He served the copy on you.
No.
The notice was served on the informant.
Yes.
All right, the Land Council for the state submits that the informant has been served with the notice as per the order of this court yesterday. Stop. In view of such submission, in order to give some time to the informant to engage counsel of his own, we adjourn the matter to the week commencing from 14th of July 2025. If any counsel appears for the informant and by filing wakalatnama, the same shall be placed on record and the name of the Land Counsel be reflected in the clause list. Yes, next.
Item 7.
On the ground of?
Marriage of the daughter of the present appellant will be held on number 29.
Can I have a glance to order 6/11/2024? The petitioner were released on interim bail.
11?
There are 6/11/2024. Thereafter, by the order dated 11/12/2024, my lord directed to file the surrender certificate. In this case, my lord, the petitioner was in love with the deceased. He committed murder to the deceased because deceased denied to marry. And petitioner here they filed this IA that his daughter is going to be married. just now they serve the copy also.
Honda.
The interim bail ଗୋଟେ ଫାଇଲ କରିଛନ୍ତି ତାଙ୍କର ଝିଅର ବାହାଘର.
କେତେ number interim? IE number କେତେ?
IN number
1661.
166.
ଆପଣଙ୍କର ଝିଅ ଆଚ୍ଛା ଅମ୍ବିକା ସତ୍ୟବାନ ଚୌହାନ କେବେ 29 ତାରିଖ
16ର occurrence 2016 occurrence. By that time the petitioner must have marriage କରିନଥିବ କାରଣ ଆସି ତ ଲଟ୍ ଥିଲା ଡିସିଜ୍ ସହିତ.
ଯାଉ ଆପଣ ବୁଝି ଦିଅନ୍ତୁ
ଲଡ଼ାଇ ଲଟ୍ ଇନଷ୍ଟ୍ରକ୍ସନ
ବୁଝି ଦିଅନ୍ତୁ ପହରଦିନ ନବା ସେ ଝିଅ ବାହାଘରକୁ ଯିବ ସେଟା ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ଦେଲେ the land counsel for the appellant files the surrender certificate which is taken on record. Hello. Next, IN number 1661 of 2025 is an application for interim bail on the ground of marriage of the only daughter of the petitioner. Marriage invitation card has been annexed to the interim application. Copy of the same has been served on the land and counsel for the state in court today. Would seek some time to obtain instruction, put up this matter on 26th of June 2025. एते डेरी काई कले निक मोमेंट रे फाइल करछंती आपण यदि जियो बाहागर तो ओवरनाइट ही नथिबो
कार्डटा भी पुओ घर तरफ कार्डटा मिसिंग.
That's what I was wondering.
आपण घर लोक चाहू नथिबे आपण बाहागर आसंतु बोली बाहागर भांगी जिवो ओते 302 केस रा आपण गोटा एक्यूज
एमन तो सब करतो देखो
ना पैसा पत्र भी नहीं कार्ड सब भी नहीं.
ओ हला ठीक है. नेक्स्ट
Item 8.
Item number 8, my lord. They have applied for bail to the IN number and for the appellate number 8, 7, appellate number 7, my lord, D. Noy Patro.
खुदिया केसमा एते लगन ए सेपरेट अफ
Barampur.
कौन है जी बरमपुर कैसे वन मर्डर
One month.
2 injured to 1 murder.
11 people have been convicted. 10 no? You don't have control.
PW 11 is the doctor, 13 external injury and 6 internal injury. 1, 2, and 3 are the eyewitness. PW 10 is the witness to the dying declaration. 4 is the 27.
रिजेक्ट जी
नहीं interim release ହେଇଥିଲା interim release ପରେ they surrender all of them
कौन पे इंटरिम बेले जाइथिला
मोर गोटे जाइଥିଲା क्लाइंट जाइଥିଲା तार आखी हठात खराब हो गेला ऑपरेशन कर
so for different reason the your client and others were
different
All of them got
all of them have surrendered.
surrender.
So let us come to your case when you were granted interim bail.
Well, 20th December 2024. CRLA number 1420 of 2023.
We got it.
Yes.
So
5/4/2025 we surrender. We submitted the surrender certificate.
in all the cases interim bail has been granted.
My case रे my lord my information.
एथरे इंटरिम बेल है मिस्टर दयानंद महापात्र केस रे हां सरेंडर
1
सर्टिफिकेट
is response present interim bail.
1417, 1418, 1419 ये तीनटा जाकर इंटरिम बेल ହେଇଥିଲା ସେଥିରେ ସରେଣ୍ଡର କରି ସାରିଛନ୍ତି 1417 ରେ 17/8/2024
ଆପଣ ଚାରି ଜଣ ପାଇଁ ବି ରହୁଛନ୍ତି.
ଆଜ୍ଞା
अच्छा बाकी रुहନ୍ତୁ ଆପଣ ତ ଯାଇଥିଲେ ସରେଣ୍ଡର କଲେ ତାପରେ ବାକି ରହିଲା ମିस्टर 130723 मिस्टर पंडा ଆପଣ ଯାଇଥିଲେ ଏଇ କ୍ଲାଏଣ୍ଟ
इंटरिम बेल ଯାଇଥିଲି
ସରେଣ୍ଡର अच्छा ତାପରେ ଆଉ ଗୋଟେ ହେଲା 47 ହଉଛି କେ ଭୀମା ପାତ୍ର
ମାନେ interim bail ହେଇନି.
ଯାଇନି अच्छा बाकी तापर आसिला 81 of 24
इंटरिम बेल
बी नई पात्र ଯାଇଥିଲେ
सरेंडर
सरेंडर कर सरेंडर ଆଉ ଗୋଟେ ରହିଲା जेल क्रिमिनल अपील नंबर 19 of 2024
केतराम जाइनी
ଯାଇନାହାନ୍ତି ଭାଇ अच्छा सो ଏଇ ଯୋଉ ମାନେ ସମସ୍ତେ ବେଲ୍ ଫାଇଲ କରିଛନ୍ତି. So madam you have obtained the instruction
regarding.
About their conduct while on interim bail.
Not it.
And number two, have you obtained the instruction about the criminal antecedent? So two things you obtained, right? Huh? Custody certificate also you produce.
In regard to all of them.
The learned counsel for the state seeks some time to produce the custody certificate of this appellant. A good pass kar debe order ta 1420. So also the appellants in the connected criminal appeals. Stop. It appears that the appellants in CRLN number 1420 of 23, 1307 of 23, 1417 of 23, 1418 of 23, 1419 of 23, and criminal appeal number 81 of 2024 have been granted interim bail, and it is stated at the bar by the respective counsel that those appellants, after availing the interim bail period, have surrendered before the trial court. Stop. The learned counsel for the state shall obtain instruction regarding the conduct of those appellants while on interim bail. Stop. How come to put up this matter on such and such date?
Yes, antecedent. Yes.
Criminal antecedent लिख लो. Criminal antecedent लिख दीजिए. So also the criminal antecedent. जोटा समस्तंगर लक्षण ना criminal antecedent. So criminal antecedent, custody certificate एटा समस्तंग पाइन, आउ conduct होसी जो माने bail ले जाए थे, है ना? साथ
jail conduct.
हाँ, jail conduct भी लिखते हैं, है ना? So that will come on 7/7/2025, है ना? अब से प्रथम टर जो order pass करिए, list this matter with CRL number so on so. अब सबूतर लिखिए कि दफ्तर में. Yes, item number 9.
Item 9.
Next week.
Deposition of today I'm having the deposition of that is not next week.
Amar darkar nahi deposition for. We have this. If you want to give it to the student council for the state. Mr. You don't want also. So prokhon do apon karo. Darkar nahi. So you want it next week?
Next week.
All right. Learned counsel for the appellant 6 for an adjournment. So next week, list this matter. So answer. Yes, next.
Item 10.
This is depends on section 302 of this matter. To undergo RI for life matter. Initially, the charge on section 498A and 302 of IPC. Put it on the section 498A, but convicted on section 302.
Are you having those deposition copies?
Yes.
All right. So 302 case.
302.
Custody since?
Custody since my lord 2017.
16/7/2022.
2020.
My lord.
On the database, my lord. That is
This is item number
16/7/2012.
Date of custody 16/7/2020. है ना?
20.
So, what is the name of the deceased?
Sabita. Like
Your wife.
Wife, my lord.
So,
Allegation, my lord.
so when your marriage took place?
For 2 years. 2 or 3 years. 3 years before, my lord. For this, 3 to 4 years before.
And you were blessed with a daughter.
Yes. That's your daughter.
And
At the time,
he
daughter
was staying in your company.
Yes.
company.
And what is the cause of death?
Strangulation.
Strangulation. Doctor reports strangulation, but in cross-examination says it is suicidal.
suicidal के में हो डॉक्टर कराने
डॉक्टर क्रॉस एग्जामिनेशन कोर्ट जो हेल्ड कले जेतु पार्लरली हिची तनो दैट इज स्ट्रैंगुलेशन but it was locked and the house was locked and
Locked from inside.
from
ना
outside.
ये आउटसाइड करी बाहर बसला
Outside
Not from
लगे-
inside.
नहीं बाहर आउट कड़ घरे
ये
was
प्रेजेंट
sleeping.
पिटिशनर
They are sleeping. The driver, professional driver, they are sleeping. But when he asked him, as per FIR, when he asked him about the whereabouts of the deceased, he said he did not know.
So you see, in your house, you were staying, your
That are
wife
the-
was staying, and the minor daughter, she was staying, and your wife died a homicidal death, and the cause of death was due to strangulation.
and the petitioner also sustained some injury during the struggle matter.
Struggle.
P6 is the doctor.
Acha. Schedule 6.
Matter.
Basing on the evidence of Schedule 1, 2, 3, who are my lord informant is the brother of the deceased, and 2, 3, their mother
Who is
and
the doctor who conducted PM?
PM
Five.
Schedule 5.
Schedule 5. Twice has been examined, my lord.
What is the status of that daughter, minor daughter who was
She is now staying with her grandmother.
grandparents?
Maternal grandparents.
Maternal, of course.
Here it is a case, my lord. Usually, that as far as the story is concerned, my lord, this accused was not staying in the house, that house, because he was a driver. Sometimes, if after 1 or 2 years, staying together, there is altercation. This person left the house, but during quarantine, the COVID time, he came and this deceased was staying in the house of her parents. But she stayed.
ଆପଣ plea କଣ? ଘରେ
Plea
ନଥିଲେ?
house, I was not there, my lord. But the defense plea is that I was not there.
Come to your accused statement where have you stated that you were not there?
Accused statement answer, but in
ତ ମିଛ କହିଛନ୍ତି accused statement ରେ ମିଛ ଜାଣିନି ଆପଣ ତ କହୁନାହାନ୍ତି ମୁଁ ଘରେ ନଥିଲି ମୁଁ ଅମୁକ ଜାଗାକୁ ଯାଇଥିଲି ମୁଁ ଯେତେବେଳେ ଫେରିଲି ଦେଖିଲି ମୋ ସ୍ତ୍ରୀର ମୃତଦେହ ପଡିଥିଲା ଆଉ ଏସବୁ ତ କିଛି କହୁନାହାନ୍ତି ଖାଲି ସବୁ ମିଛ କଥା।
Rather, the petitioner stated to her mother-in-law that her wife had been with her father-in-law to some other village. ତା ମା କୁ ଯେତେବେଳେ ତା ଶାଶୁ ଯାଇକି ପଚାରିଛନ୍ତି କୁଆଡେ ଗଲା ଝିଅ
କେତେ ନମ୍ବର ସାକ୍ଷୀ?
Schedule 3.
2.
Sorry, 2.
2 ହଉଛି sir.
So false statement made that
Yes.
ସିଆଡେ ଯାଇଛି ବୋଲି
ଯାଇଥିଲି
ଘରେ ଡେଡ୍ ବଡି ଟା ଘରେ ମିଳିଲା ଆରି ଘରେ
ଘରେ ମରିଲା ସେ ଯୋଉ ବାହାର ଲକ୍ ହେଇଥିଲା ମିଳିଲା କିନ୍ତୁ ସେଇ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଟା କଣ୍ଟ୍ରାଡିକ୍ଟ ଟୁ ଏଫଆଇଆର ହେଲା। ଏଫଆଇଆର କହୁଛନ୍ତି ଏତେ ପଚାରିଲୁ ସେ କହିଲା ନା ଏଠି କହୁଛନ୍ତି କଣ ନା ପଚାରିଲୁ ଯେତେବେଳେ ସେ କହିଲା ବାପା ସାଙ୍ଗେ ଯାଇଛନ୍ତି।
ଯାହାହେଲେ ଯେ ଆପଣ ସ୍ତ୍ରୀଟାକୁ ଗୋଟେ ତଣ୍ଟି ଚିପି ମାରିଛନ୍ତି 5 ବର୍ଷ ରହିଛନ୍ତି ଆଉ
କହୁଛନ୍ତି 1.5 ବର୍ଷର ଛୁଆଟେ ତାଠୁ ଶୁଣିଲୁ ଯେ ସେ ମାରି ଦେଇଥିଲେ।
ସେଟାକୁ ରହିଛି ସେଠି ଯାଇକି
struggle period ମଧ୍ୟ accused ଦେହରେ ମଧ୍ୟ injury ଅଛି Schedule 6.
1.5 ବର୍ଷର ଛୁଆଠୁ ଶୁଣିଲେ ବୋଲି ତାଙ୍କର ଷ୍ଟୋରି ହଉଛି 1.5 ବର୍ଷର ଛୁଆ ଯେ ସେ କହିଲା ଯେ ବାପା ମାରି ଦେଇଛନ୍ତି 1.5 ବର୍ଷର ପିଲା କିନ୍ତୁ ପିଲାଟା କୋଉଠି ଥିଲା ଦ୍ୟାଟ ଇଜ ନଟ୍ ପିଲାର କୋଉଠି ନାହିଁ ଯେ କୋଉଠୁ ଥିଲା କଣ ହେଇଥିଲା କୋଉଠି କାହାକୁ କହିଲା କିଛି ନାହିଁ।
argu those in at the time of final argument. Look on the IN number so and so this is an application for bail. It's a case where the charge against the petitioner is that he committed murder of his wife Sabita by strangulation. Evidence of PW5, the postmortem doctor clearly indicates the cause of death. The petitioner was staying with the deceased wife and the minor daughter who was aged about 1.5 years at the time of occurrence. The land counsel for the state submits that in the accused statement, no explanation has been given by the petitioner as to how his wife died of homicidal death. He further submits that when the appellant's mother-in-law was examined as PW2, asked about the whereabouts of the deceased, it was told to him by the appellant that the deceased had gone somewhere.
Accompanied with her father to some other village.
The appellant, the deceased had accompanied her father to a nearby village. Land counsel for the petitioner submit that the petitioner is in judicial custody since 16/7/2020, and there is no likelihood of the appeal being taken up for hearing in the near future, and therefore the bail application may be favorably considered. In view of the available materials on record, we are not inclined to release the petitioner on bail. The petitioner is at liberty to renew the prayer for bail after 1 year for them. If in the meantime the appeal is not taken up for hearing.
Item 11.
Mr. Panda.
May I please, Your Lordship? I am from BC, Your Lordship.
Yes.
Your Lordship, Mr. Panda is on accommodation, Your Lordship.
You want adjournment or?
Yes, Your Lordship.
What is your good name?
Devi Vatsala Rath.
Mr. Rathol and counsel appearing for Mr. Devasis Panda, 6 for an adjournment, adjourning matter. Yes, next.
Let the declaration
Oh, bless you.
last occasion and also try to stop the declaration copy of the.
Mr. Counsel, you have
It's gone already. Next time we will see.
you have not solved the deposition copies which
Yes,
was
sir.
ordered.
We'll file.
In the meantime, the London Counsel for the appellant shall solve the deposition copies of all the witnesses examined in the trial court. London Counsel for the state. Yes.
Deposition copies are not with me.
Deposition
copies are not.
not with you. So what do you want?
Deposition copy provided with my KT matter.
Item 12 you are talking about. Yes.
Item 12. So trial court record is there. So you want soft copy is there. So give your pen drive and take it. And both of you take the deposition copies in the pen drive. Right. The London Counsel for the appellant submits that the copies of the depositions are not available with him, and the registry may be asked to supply the deposition copies in his pen drive. Similar prayer has been made by the London Counsel for the state, right? Let the registry supply the deposition copies of the witnesses in the pen drives of the Land Counsel for the appellant, so also the Land Counsel for the state. Put of this matter in the week commencing from 7/7/2025. Yes.
Item 13.
May I plead your lordship? We are three appellants. We have been convicted of the life imprisonment under 302 and 34. We are in custody since 7th July 2022. And we are
You are having the deposition copies?
We have filed the along with the picture.
Is it up? Okay. So, how many appellants are there?
My lord, 3 appellants are there.
For all the 3, you have filed the bail application. So, all the 3 have been found guilty under section
302 and 34.
34 IPC. Is it a case based on direct evidence or circumstantial evidence?
Actually, only 3 eyewitnesses are there. 11, 17, and 18.
11, 17?
11, 17, and 18.
11, PW 17, and PW
18.
18 are the 3 eyewitnesses.
3 eyewitnesses.
And who is the doctor who conducted PM?
Informant is number one, PW1.
कौन पचरा होची कौन उत्तर दउछन डॉक्टर किए जे पोस्टमार्टम करथिले आपण जाडू सर ऑर्डिनेंस जदी आउ दिन आनियो नोट पे रखतांगे ना पढ़
And that is PW19.
Sure.
Right.
PW19 is the doctor who conducted PM examination.
Right.
Okay. So,
On 4 grounds we are applying.
what is the name of the deceased?
Sudhir Behra.
Sudhir Behra.
Right.
So, what is the weapon of offense?
Weapon of offense, one medha and one iron rod. Madam, on core grounds, we want to this for the bail. That is actually the occurrence occurred on 2nd July 2022, but at 6 p.m. But the FIR was given on 4th July 2022. After 48 hours. And the occurrence occurred at the Ratha Jatra. And there are not a single witness, only these 3 witnesses are there, who are the friends of the deceased, who is the criminal himself, and all these 3 had come.
Our रथयात्रा जेतिको लोक जाइतले समस्तଙ୍କୁ prosecution examine करथांदा.
नहीं काहाकू गोटे भी केस ना तुमको समझ
So you want the quantity of evidence or quality of evidence? What is 134 of the evidence sir?
Actually,
So it is the quality of evidence which matters. Even if the evidence of a solitary witness is believable to be true and trustworthy, the conviction can be maintained on the basis of such evidence. It is not necessary that 100 witnesses will be examined. So रथ यात्रा को जाइथिले से जो लोक एग्जामिन नहीं नांती
I want to insist on the quality of the witnesses because all the 3 witnesses are friends of the deceased.
So what they were present?
All are the
They had gone to see Rath Yatra with the deceased, and they have stated how their friend was assaulted and died. So why they should be disbelieved merely because they were friends? They were natural witnesses because they were present with the deceased at that point of time.
No, my lord, why you want to say because the gap in the time, they are all criminals, they have gone somewhere and they have been killed, and now they are telling that it was happened.
Medha and Iron Rod Ray, all the 3 persons assaulted, that is the evidence, the eyewitnesses. And if we see the evidence of PW19, the doctor has noticed injuries on the neck, occipital region, right parietal region, vortex, and wrist joint. So these are all, at least some 4 are the vital parts of the body, and the cause of death has been opined due to injury to the head, cerebrovascular injury and its complications thereof. Injuries are sufficient in ordinary course of nature to cause death.
Well, I want to submit that it is in Rathayatra. Actually, the police had been deployed there. If any incident would have occurred there, police would have given a second night. It was never there. It was there on court, and they have not explained why the delay was there. The 21 page, witness number 21.
In the FIR itself, he has stated that after the assault took place, the deceased was taken to Himavoi Medical, and then his condition he became further serious. Then he was shifted to Burla, and then he was taken to AIMS Hospital. He was kept in the ICU. तो ए 3टा हॉस्पिटल को एमाने नेकिनी गोटे पर गोटे हॉस्पिटल को गले तो so obviously it has explained the delay.
No,
this occurrence took place.
Sister of the victim, and sister was never gone with him anywhere.
The primary concern of this person is to save the life.
Save the life.
And those the matters are to be argued at the stage of argument when the final hearing.
For the purpose of bail, 3 witnesses eyewitnesses has very categorically implicated you.
And see the number of blows you have given on the vital parts of the body. Gote ବ୍ଲୋଟା ଅଛି ଆପଣଙ୍କର ରିଷ୍ଟରେ, ବାକି ସବୁ ତକ ଆପଣଙ୍କର ମାରା ହେଇଛି ମୁଣ୍ଡରେ, ଏପଟ ସେପଟ ଆଉ ନେକରେ।
Except these three, nobody is telling. ଗୋଟେ ଦେଖିଥାନ୍ତା ବାହାର ଗୋଟେ independent witness. They are all interested witnesses. All three are interested. And sir, page 103 ରେ ସେ ଯୋଉ ଆୟୋ କହୁଛନ୍ତି delay of lodging FIR was not explained by the informer. ସେ କହିଛନ୍ତି 103 page 103 para 12 ସେ କହିନାହାନ୍ତି।
Right. You are in custody since when?
7th July 2022.
22 only.
Who are from the FIR and another one from 23rd 7th 2022.
July 22 ରୁ ଅଛନ୍ତି ଆଉ
ହଁ ସାର୍ ଜୁଲାଇ।
Are the learned counsel for the petitioners, learned counsel for the state? The learned counsel for the petitioners submit that the petitioners are in judicial custody since July 2022 and the prosecution has not explained the delay in lodging the first information report, FIR work, in as much as the occurrence in question took place on 2/7/2022 at about 6 to 6:30 in the evening hours, and the FIR was lodged on 4/7/2022. The learned counsel further submits that all the three eyewitnesses, that is PW11, PW17, and PW18, are the friends of the deceased Sudhir Behra, and though the occurrence in question stated to have taken place during Rath Yatra, but no independent witness has been examined by the prosecution, and therefore there are good chances of success in the appeal, and balance of convenience is in favor of the petitioner, and therefore the bail application may be favorably considered. Stop. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that the three eyewitnesses have specifically implicated the petitioners who have assaulted the deceased by medha and iron rod, and they were the friends of the deceased and were present with the deceased, and therefore they are natural witnesses, and it appears from the prosecution case records that the deceased was first taken to Bhimaboi Hospital, Balangir, and then shifted to Burla Hospital, and then taken to AIMS Hospital, Bhubaneswar, for treatment, and was kept in the ICU. Therefore, the delay has been explained by the prosecution, and the doctor PW19 who conducted postmortem examination has noticed number of injuries on the vital part of the body and opined the cause of death due to cerebrovascular injury and its complication, therefore, and therefore the bail should not be granted to the petitioners. Considering the submission made by the learned counsel for the respective parties, in view of the statements of the eyewitnesses coupled with the evidence of the doctor PW19 and the postmortem report findings, we are not inclined to release the petitioners on bail. Accordingly, bail application stands rejected. Stay realization of fine. Yes, next.
Item 14.
Shyam Manohar.
My lords, I'm appealing through VC. My lords, I'm appealing on behalf of my senior Mr. Shyam Manohar. My lords, can I proceed? My lords, it's a criminal appeal files against the conviction under
There is
section
a
C.
delay of 708 days.
Yes, my lords. My lords, we had filed 4 IAs in this. My lords,
No, we are now first concerned with the delay condonation
My lords,
application.
kindly appreciate. My lords, there was a genuine reason behind the delay. My lords, both the parents of the
And you are not filing the certified copy of the judgment?
my lords, actually, my lords, both the parents of the petitioner is like no more like passed away in this phase. She only has an younger sister who is like unmarried. My lords, we have filed an IA regarding this. As soon as we'll be getting the certified copy, my lords will be filing it.
No. You see, the copy which has been filed by you is
Yes, my
even
lord.
not the true copy of the judgment, where usually the court seal and the signatures are given. So how can it be taken to be an authentic copy of the judgment?
My lords, we have received this one, and my lords, I'll kindly pray that my lords will be.
File the certified copy, and we are giving also you time to file objection, if any, to the delay condonation application. The officers pointed out that the certified copy of the impugned judgment has not been filed. The learned counsel for the petitioner has filed an application for dispensing with the filing of the certified copy of the judgment. Stop. The copy which has been filed by the petitioner doesn't even bear the seal of the court or the signature of either the presiding officer or the court master. Therefore, we are not able to accept such a copy, and time is given to the learned counsel for the appellant to file the certified copy of the impugned judgment. Stop. The learned counsel for the state submits that there is delay of 708 days in filing the criminal appeal, and intends to file an objection to the interim application wide IN number so and so filed by the appellants for condonation of delay. This matter, give it after 2 weeks provision.
My lords, obliged.
Item 15.
Well, please. The petitioner was charged and charged under section 302 of IPC and imprisoned for life and fined the 10,000.
So you have to produce the custody certificate and obtain instruction about the criminal antecedent. That was the order passed on 30/4/2025.
Custody certificate.
Copy of the custody certificate enclosed. ABC ହେଲା 3488 दिन केते आछी जरा केते वर्ष के दिन 10 वर्ष तो होई नथिवो 9 वर्ष खंड हो हरि दिन कोंतो अच्छा बाकी रहिला आ गुटे कोन कहतला आनिया पे आपन को
क्रिमिनल एक्ट
किछ अछि नाही
Yes.
कोन यादर कोन अछि 302 केस सो आई विटनेस अछंती
eyewitness
किए आई विटनेस किए
PW4, PW8 मतलब.
जणे
आज्ञा. He said actually he is not an eyewitness.
Just-
He's the post referee.
तो प्रोसिक्यूशन केस होन जे PW4 होची आई विटनेस
PW8 मतलब.
PW8
PW4.
जणे तो PW8 होची आई विटनेस और डॉक्टर किए PM
PW4.
PW4 होची PM डॉक्टर को वेपन नंबर आईची with X so PW8 evidence person I know the accused Swansea was working as Swansea and all of us sleeping inside the accused came and gave 2 close by mention acts to Suru Dharwa. This is now the Suru Dharwa. All of a sudden I got up and shouted at him as to why he was giving blows to Suru by means of said weapon. Accused fled away. I rushed outside the room, finding Swansea, who was washing the Swansea. I ran towards the nearby field to call Lali, who had gone to attend call of nature. At the field, I saw the appellant was assaulting Lalit by means of this acha. Lalit पहुंचला ना सीएम भी मर गया वैसे केस ऑफ डबल मर्डर ललित का नाम पूरा ना कौन
ललित मिश्रा आणि त्याला सुरू
दारुआ
सुरू सलवन धर सुरू सेल्लम धर
कस्टडी केते वर्ष हला कस्टडी देखि
6 वर्ष
6 वर्ष
9 years
9 वर्ष केते
and the PM has been conducted on both the deceased by PW4.
माइला
Postmortem এই জনে ডক্টর করছি তো দুই জন ডিসিস্ট করো
yes ma'am yes ma'am. But
court wound was noticed in
MO has not been violated, no material object has not been proved, and I have also not received the chemical examination certificate.
Lalit Mirtha, court wound, so sure.
Eyewitness also is not an exact eyewitness, but the post occurrence eyewitness. These are not eyewitness, the post occurrence witness.
Eyewitness is not an eyewitness, but is a post-occurrence witness.
Yes, my lord.
How you say so?
My lord,
He has stated in the chief examination that he had seen the appellant dealing the blows, axe blows on not only the Suru, but also on the Lalit,
yes.
who was attending the call of nature. So on what basis you are making anything you have brought out in the cross-examination?
Cross-examination, my lord. If the occurrences occurred in the some Bhushan Steel Company Limited, so there is some in the cross-examination in the paragraph 4, my lord, point 4. PW8, there were 3 rooms adjacent to the case room. The accused was staying in a separate room. There was previous dispute between the accused and the deceased persons, for which both of them had been shifted to my room. I cannot say the names of the other persons staying in the adjacent room. I cannot say the name of the Bihari old man. I was performing my duty inside the plant premises. The deceased persons and the accused were also performing their respective duties inside the plant premises. It is a fact that at the time of entry and the exit inside the plant, security checking were conducted. It is a fact that at that time the security personnel verified the gate pass of the employees. It is a fact that while leaving the plant premises, we used to leave the working tools inside the plant. It is a fact that the worker was not permitted to keep any working tools in his room.
No, from this paragraph 4, how can we say that he is a post-occurrence witness? What have you elicited?
Here the judgment also.
Judgment hold karichi PW4 8 is a post-occurrence witness.
The defense that means.
Paragraph 4 ru to ki jana purni he is a post-occurrence witness but posed himself as an eyewitness to the occurrence.
all were sleeping on that night, the all were sleeping. ସେ ଖାଲି ଦେଖିଲା ଯେ ତାକୁ ବାଡେଇକିନା ସେ ଦୌଡିଲା but ସେ ଦେଖିନି କି ତାକୁ ମାରିବାର ତାଙ୍କର dispute ହେଇଥିଲା ସବୁ
No, accused, while we are sleeping, accused came and gave 2 blows by axe, and I got up and shouted at him why he was giving blows. Then he fled away. ତାପରେ ଇଏ ତାକୁ ଫଲୋ କରିକି ଗଲା। ସୋ ଯେତେବେଳେ ଏମାନେ ପାଖରେ ଶୋଇଛନ୍ତି ସମସ୍ତେ ସେଇ ସମୟରେ ଇଏ ତାକୁ ଆକ୍ୟୁଜ୍ଡ ଆସିକିନି ମାରିଛି, ଆକ୍ସରେ ମାରିଛି। ଆଉ if we see the evidence of the doctor has noticed that this deceased Suru has sustained 2 cut injuries, one on the neck and the other is on the right side face. So उठिकिनी देखिथिबो कोन हला जदि भी पाकर सोईथिबो पार्टी हेतिबो।
examined very much of post of place in the see one of the paragraph.
The counsel for the state has produced the report of the previous superintendent's of the summer, which indicates dated for the 4th May 2025. It indicates that the petitioner is to be
now versus 9 years, 183 days. 183 days.
Sorry,
Is described in the month of August 2025. This is taken on the phone. And already the United Council for the state 6 some time to review the instructions related to the yes.
Item 16.
16 notice টা যেতলা কিন্তু কনফার্মেশনটা আছে ইনফরমেন্ট আছে।
Will the council owning the past the channel why is not present? Been engaged by the legal aid. I proceed. Running
I will enter.
The file number wants to be an application for confirmation of the electricity. The land council for the state submits that he has is late to receive the instruction from the concerned police station regarding service of notice of the foreman. The matter may be taken up after 2 weeks. More appears for the Brandon Amicus to Mr. Adi Kumar Srichandam is not present. The council of the state. So they submit that we estimate Mr. Srichandam for the listing of this land. Next.
Item 17.
May I please, Your Lordship? I am on BC, my lords. Your Lordship, have a glance to the last order, my lord. This is an appeal.
There is the letter was issued, but intimation given from
Counsel for the complaint, we use the explanation and received from the presiding officer. See for the order dated 7/5/2025. Also the explanation published by the presiding officer. The result for the
The report was called for about the filing of appeal by the state has prepared any appeal against order of acquittal or judgment. That is the superintendent of police was presented, the APP opinion has been sought for. After obtaining that opinion, the decision is said.
Public trustee present. Also, time of the land council for the state that the opinion of the current topic was conducting the trial has been sought for. The Land Council for the state submits that the opinion of the public prosecutor who was conducting the trial has been sought for to prefer an appeal, if any, challenging the impugned judgment and order of conviction passed by the Land and Trial Court. Stop. In view of the submission, place this matter on such and such date. It's a by the way, it is a acquittal order has been challenged. Okay.
Yes.
So you get that instruction, otherwise we'll proceed with this, because he has filed the, as a Mr. S.S. Roy to Land Counsel for the informant, bracket, oblique, victim, bracket, like the appellant is present, will you like them, no? So, anyone is ready in this hearing matters? ऑथर नंबर report
item 27 the appellant dead report
27 telephone.
Sole appellant?
Mallet.
The Land and Council for the state, as per the order dated 1/5/2025, has produced the report of the IAC Bhograi Police Station, Palasur, that the appellant Kanu Charana Malik is dead. The report is taken on the death certificate of the appellant is annexed to the said report. The report is taken on record. The appeal abates and accordingly disposed of. Yes. Any other matter you have received any instruction?
Item 18.
Item number
18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18
ଆଦେର କେତେ ଜଣ ଆପେଲାଣ୍ଟ ଥିଲେ? 2 ଜଣ। ତାକୁ କଣ ଧୁକୁ ବେହେରା ଆଣ୍ଡ ଭକ୍ତ ବେହେରା କଣ ଆସିଲା ଇନଷ୍ଟ୍ରକ୍ସନ? So they are all alive. Cultivation work କରୁଛନ୍ତି। हाँ हाँ नहीं ठीक है। The Land and Council at item number 18 लिखिए। The Land and Council for the appellant, sorry, state has produced the written instruction received from IIC Model Police Station Board, which indicates that the appellant appellants कर दियो in this jail criminal appeals also in the connected appeal, that is CRLA number 410 of 2006, are on bail and they are all alive. The report is taken on record. Eta ready want to eta sunani pai baki au kothra anisandi?
Item number 90. There is a report of 2023 that he was alive.
Okay.
There's a report of 2023 available on record that he was alive.
Get the up-to-date report. What number item cheda?
19.
19. The Land and Council for the state submits that though he has received a report from the year 2023,
2023.
2022,
2023.
regarding the well-being of the appellant, but she seeks some further time to obtain a latest report in that regard. List this matter in the week commencing 2 सप्ताह पर report देंगे। How phone to on the matter? 22 नहीं ये जो 20 और 21 कौन है ना? ସବୁଥିରେ ଅଛି ନା?
21 I seek some time.
अच्छा 20 टा କୁହନ୍ତୁ ସିରିୟଲି ଆମେ ଯାଉଛୁ ନା 20 ଟା କୁହନ୍ତୁ 20 ଟା ହଉଛି ଆଇଟମ ନମ୍ବର 36 JCRL 36
Instruction immediate.
अच्छा ଏଇଟା ନାଇଁ ଏଇଟା ହେଇଛି he is in jail custody so it is okay ତାହେଲେ ଜେଲ କେ ଏଇଟା ଶୁଣାଣି ହବ ତାପରେ 20 ଗଲା ତାପରେ 21
अपील मेमो में काइंडली सॉल्व
अच्छा କୋଉଥିରେ ଆଇଟମ ନମ୍ବର 20 ରେ अपील मेमो नु आपण धीरे पेपर बुक नेबे हैला अच्छा यू आर मिसेस महांती अच्छा मिसेस विदुलता महांती Land and Council for the appellant is present. She submits that she may be served with a copy of the paper book. Stop. Let a copy of the paper book be served on the Land and Council for the appellant. আজি অপেক্ষা করতে ম্যাডাম নেই যাবে আমার সিগনেচার করে দিয়ে দেবেন and it will be in the hearing list হলো get ready. Now we will come to item number 21. You want some time? As a Land Council for the state seeks some further time to obtain the instruction as per the order date देखी देगा उसे जो well ना कौन उठा मगाई था now 22 रे कौन आसिला 22 दियन released on bail and alive. Okay. The Land and Council for the state has produced the report from so which indicates that the petitioner, that the appellant is on bail and he is alive. No. The reports are taken on record.
23 I request some more time.
এটা মানে কালি কি এটা আড করে দেবে মানে হিয়ারিং লিস্টে রইবে ওটা যোড়াক আর্জন হউনি এগুড়াক কমপ্লাই হয়ে গেল মানে এটা হিয়ারিং লিস্টে রইবে আচ্ছা ঠিক আছে ঠিক আছে তাহলে কোটি ডেট দিয়ে দেবেন নেক্সট তারপরে আইটেম নম্বর 23
Some more time.
আচ্ছা মোর টাইম দিয়ন্তু নেক্সট
24 मिला 18/12/24 he is in bail. But we are sending the letter to for the alive of the country that report has not come.
You need time then.
24 रे से bail ले अछन।
नहीं ठीक है जी एटा JCRL नंबर 75 रे लिखंतु the Learned Counsel for the state submits that he has received instruction that the appellant is on bail. ठीक तो?
12/2024.
But he may be given some time to obtain instruction regarding the well-being of the appellant. Hello? This matter. Do
Item 20
with CRLA number 40 of 2012. ठीक तो? Next.
25 minutes. We pay some more time to.
More time beyond. Next.
Item 26.
26 minutes, 6 some more time to obtain the
More
well-being.
time granted.
Paper
Next.
was not supplied, paper book, I may for the technical.
Acha. Let a copy of the paper book be supplied to the Land Council for the state. Next.
Item 28.
Acha. The Land Council for the state has produced the report from Swanshaw that the appellant is alive. The report is taken on record and it arrive hearing list. Tapare
Item 29.
29 also has granted bail on 2024 only. No report has come.
but well-being report you have not received.
I'm not.
Look on it. Receive the report that the appellant is on bail and she seeks some other time to obtain instruction regarding the well-being. Hello, next.
Item 30.
The same appellant has filed another appeal, JCRLA number 79 of 2017 with so and so. Acha. It appeal kong P. Krishna Patra. আগটা রইব এটা জীবন দেখি আগে দেখি দেওয়া দুইটা সমান কি নাই প্রথমে আগে বাহার করুন 84টা বাহার করুন 84টারে জজমেন্ট কু আসন্তু জজমেন্টটা হচ্ছে না হলা নিরো আলিয়াস নিরঞ্জন প্রধান আচ্ছা কেস নম্বর হলা সিটি এসএস 90 of 2008 डेट हला जजमेंट 29/6/2010 Swanso is the session judge Enkana তারপর পড়ে আসুন সেটা আরটা
সেম
জজমেন্ট 29/6 সেম লোক ঠিক আছে 16 লিখুন JCRLA number 79 of 2017 এ লিখুন তো since the appellant has earlier preferred another appeal, that is JCRLA number 84 of 2010, which has been admitted and sub judice before this court, challenging the self-same impugned judgment and order of conviction, this JCRLA is disposed of. Hello? Stop. তারপরে নেক্সটটা কোনটো সেকেন্ডটা ডিসপোজ অফ হয়ে গেল 79
That report কোন আছে 33 30 number item report
তাদের মগাইনি কিছু
হ্যাঁ
30 রে কিছু মগাইনি
রিপোর্টটা পড়েন
2010 রে মগাইনি তো নিয়ে আসନ୍ତୁ whereabouts report নিয়ে আসো এই যে তার স্ট্যাটাস এটা তো বেল ହେଇନି মানে ଥିବ ବୋଧେ ଆଉ ତଥାପି ମ ନେଇ ଆସନ୍ତୁ ଦେଖନ୍ତୁ since this is an appeal of the year 2010 let the Learned Counsel for the state obtain instruction এই যে আগুর যে ইয়ে না about the status of the
status well-being jail conduct and all
jail conduct ওরা সব নিয়ে আসুন কোথায় আইটেম নম্বর যে প্রথমটা 30 ର ଯୋଉ ফার্স্ট আইটেম 84 ওকে নেক্সট হଉଛି 88 রে কয়লা
তার রিপোর্ট মগাইনি সেন্ড দ্য লেটার
হ্যাঁ
31টা ବି সেম
না এটা তো অর্ডারটা অলরেডি ଅଛି 31 ରେ ଅର୍ଡର ନଥିଲା ଏଟାର ଅର୍ଡରଟା ଅଛି ଆପଣ ଆଣିଲେ କି ଷ୍ଟେଟ୍ ଟୁ ଅବଟେନ୍ whereabouts
ରିପୋର୍ଟ ଆସିନି
ଆଚ୍ଛା এটা ଫର୍ଦର ଟାଇମ୍ ହଁ ଗୋଟେ ପରେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା ସେକେଣ୍ଡଟା 79 of 2017 ଟା ଯୋଉଟା ପରେ ଫାଇଲ ହେଇଛି ଯେହେତୁ ସେ ଆଗରୁ ଗୋଟେ ଅପିଲ ଫାଇଲ କଲା ଏଇଟା ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା ବର୍ତ୍ତମାନ 84 ରେ ସେ ରିପୋର୍ଟଟା ଆସିବ ଆଉ ବାକି 31 ରେ ସେ ଟାଇମ୍ ମାଗୁଛନ୍ତି to comply the order dated to produce the report of one. Yeah, so
Patra, 88/2010. Item 31, 88/2002, release of bail.
31 ने किसी तो बेल फेल नहीं बेल जाइची हाँ जाइची तो आनी से बंची की कौन है नहीं जो आसु आसु तो नवा
Madam.